Good afternoon, folks. We have 8 hours of requested argument, and I imagine no one wants to be here for the next 8 hours. So what I would ask you to do is advocate your strongest positions to us. You don't need to educate us. I assure you, we are all a hot bench. First case on the calendar is People versus Thomas Foreman.
Respondent request 4, Your Honor.
4, 1, and 4. Nationwide General versus South.
Nationwide, 5 minutes, Your Honor.
I don't see an adversary. Do you want to submit?
I defer to 3 minutes.
How about 2 minutes? You got it. Third case is A. Amelia. I'm sorry? 4, 1, and 4. 4, 1, 4, and 4. Texeria versus Texeria. Submitted. Kaufman versus A.O. Smith. Submitted. People versus Robert Story.
Appellant request 4 and 1. Respondent request 5.
4, 1, and 4. Barton LLP versus Maybank.
Appellant request 4 and 1.
Respondent request 4 minutes.
I see you guys are now seeing the game plan here. East 54th Operating versus Brevard Owners.
Appellant request 4 and 1.
You got it. 4, 1, and 4. Cinco Inc. versus Zhang. Yeah, appellant's on the screen, so appellant?
Can I be seen, Your Honors? I'm sorry, I feel as though there might be, my screen is black. Okay, I fixed it, sorry.
Okay.
Sorry, Your Honors.
Yeah, I just want to say that we also have screens on our, on the bench and we can see you. So how many minutes do you want?
Okay, great. Just 4 and 1, Your Honor.
4 and 1? Okay, you got it. And then folks, Simcoe I'm going to call first because it is a remote argument.
Shine.
People versus Harry Rees, submitted. Fushi versus JP Morgan Chase Bank. Very good, submitted. Continuum Energy versus Iron Oak.
4 and 1 for the appellant.
Got it. SRS Enterprises versus Rosemax Inc. Got it. Kramer versus Bailey Restaurant. 4 and 2, and Bailey. Okay, so it's 4, 2, 4, and 4. People versus Patrick Hoover.
Respondent request 3.
5, 2, and 3. Titan Industrial versus Navigators Insurance. Very good. Richardson versus the Housing Authority.
Respondent.
I don't see an appellant. Do you want to submit?
Unless the panel has any questions, I'll submit.
Colleagues? We're good, thank you. People versus Esquilin. 5, 1, and 4. Bedell versus Eros Management.
On the request 5, Your Honor.
Okay, and Mr. Isaacs, I'm not going to give time on the non-enumerated discovery case, because that's, yeah, okay, very good, okay. Okay, first case on the calendar is People versus Foreman. Oh, I'm sorry, my bad. We are doing Shineco first. So Shineco, step up, please.
Your Honor. We don't represent Shineco, we represent the appellants who are different parties, just to make clear.
Okay, who do you represent?
We represent Lei Zhang and Yan Li, who
Okay.
are the defendants in the underlying action by our appellants in this case against cross-claim defendants, TransShare.
Okay, you may proceed, counsel.
May it please the court, Jenna Low on behalf of appellants Lei Zhang and Yan Li. Appellants are record shareholders of shares in Shineco, a public company. Appellants requested that the transfer agent TransShare remove restrictive legends from their shares. And for close to half a year after that request, TransShare did not remove the legends, although there was no injunctive court order in place to stop them from doing so. In the meantime, the price of the shares.
If I may
Yes, Your
ask
Honor.
one question, does it matter that an application had been made for the injunctive relief, or did it need to be granted?
Your Honor, that's a very good question. It goes to the core of the case. A mere motion had been made. Indeed, it has to be obtained, and that's clear from the statute. If we look at section 843 of the UCC, subsection D, I believe, it says that it has to be obtained. The words are obtained, and what has to be obtained is something which is enjoining the registration of transfer of the shares. So just to answer you very briefly, Your Honor, there needs to be an actual order which is enjoining the registration of transfer. A mere filing is not enough.
But
It
doesn't that put
impose-
the, sorry,
Go ahead.
doesn't that put
Yes, Your Honor.
doesn't that put all of the interested parties here sort of at the mercy of the court and its timeline and its discretion in determining whether or not to grant injunctive relief?
Well, Your Honor, there is, there are provisions which can be made for this kind of situation. Most of the time, if you apply for a TRO and a preliminary injunction, the TRO comes up pretty quickly, and that is what happened in this case. I think it was on November 26, 2021, when Shineco itself applied for an injunction. It was heard on December 1st, which was within days, and the TRO itself was denied, explicitly denied by the court on December 3rd. So,
But
this is
then,
not the kind
counsel,
of
let me interrupt you just a second, please. But the preliminary injunction was granted, correct?
Yes, the preliminary injunction
So
was
say the
eventually
court says, you know what, I don't have enough papers, the TRO, and in fact, the commercial division rules in New York County say that you can't grant an ex parte TRO, and if you put one on for the next day, the other side generally doesn't have the time to put in papers. So the court says, okay, I'm not going to, under the commercial division rules and most court rules, federal and state, I'm not going to grant the TRO because the parties don't have enough time. I'm going to put it on for a hearing. And if the hearing doesn't go in 30 days, it's your position that the transfer agent is required to release the no-sell restriction, even though a day later, the court would have granted the preliminary injunction? And in fact, that's what happened here, right? The court did grant the
Well, Your Honor-
preliminary injunction, just not within the 30 days.
Yes, Your Honor, the court did grant eventually a preliminary injunction, but that was 5 months after the initial request was made. So, it's not a matter of it being 31 days or 32 days with respect to Your Honor, but it's as long as 5 months. And
But
in,
that
on
5-month
that-
period, was because of the court schedule, right? It wasn't
Well-
by either party, it was the court schedule.
Well, Your Honor, the court's handling of this case was quite complicated, and please allow me to take you through it because it wasn't quite an ex parte TRO. Both parties were involved. On December 3rd, the court explicitly denied and declined to order a TRO After having had the benefit of further briefing from both sides, Your Honor, over more than a month, on January 19, 2022, there was a hearing, an initial hearing of the preliminary injunction, at which point the court explicitly stated, I'm not ordering anything here today. I'm not ordering a TRO. And so again, more than 2 months after the request was made, and way more than a month after the initial filing of the motion for
So let me
injunctive
stop you
relief.
there for a second.
Sorry. Yes.
So one way to look at it is, you know, the transfer agent is in a difficult place. If it had complied with its letter saying that there were 30 days to obtain the injunction, did the transfer liability, if there had been compliance per the statute, could the transfer agent then be held liable for complying with the statute?
I'm sorry, Your Honor, could you just repeat that?
Could the
Liable
transfer
for
agent be
complying-
liable to the plaintiff for complying with the statute if it had removed the restrictive covenant within the 30-day period?
Yes, that's a good question, Your Honor. I don't know what the content of their specific contractual relation.
No.
like,
I'm talking
contractual
under
arrangements.
the Delaware statute. Under the Delaware statute, is there a liability, or are there provisions in the statute, including 8-115 and 8-403D, which would insulate the transfer agent from liability?
Yes, Your Honor, thank you. So 840 8404, I believe, provides for very limited and protected circumstances in which there might be a little bit of liability to the issuer of if the transfer agent does register a transfer. But if one looks at the text of 8404, which I don't have quite right now, but and I can call up later if
Could
required,
you finish up
it's
your,
very
I'm sorry, finish up what you're saying, because the red light's on and I'm not sure if you can see it. So go ahead and finish up your thought.
404 is where we find some very limited liability, but that is very limited. And I believe that under 403, it's either B or D, or at the end of 401, I'll get back to you later. There is actually an immunization from liability. I'll get back to you on that later. Thank you.
Counsel. So picking up on that, had there been compliance with the Delaware statute within 30 days, could there have been liability?
No, our argument would be if there had been compliance within 30 days, then 8-115 would exculpate the transfer agent. But more importantly, I think there's a narrower focus, which is under this specific set of circumstances where the issuer has stepped in and moved for an injunction, it's unreasonable to expect the New York courts to decide within 30 days on the injunction motion. And under 8-401B, the transfer agent standing in the shoes of the issuer can only be liable to the shareholders if it unreasonably delayed issuance of the unrestricted shares.
But does the statute comply with what you're saying? Does the statute say move for injunctive relief, or is it more mandatory language in it?
So the statute speaks in three different parts. It says obtain, as Ms. Lowe said, but it says obtain legal process or injunctive relief. Our position would be the issuer here as the shareholder, which had directed my client not to transfer the shares, had said that they hadn't been paid for. So my client was facing contradictory orders as to what to do with the shares here. They had sought legal process. They had come in, they had asked for an injunction.
But that's not consistent with the statute. You would concede that, right?
Well, the statute says legal process, which isn't defined.
But it says 30 days too, then.
It says within 30 days unless there's an unreasonable, without unreasonably delaying.
So I draw your attention to 8403D, which seems to suggest that if there is compliance and within the time period, that there's no liability.
Yes.
Correct?
Under 8-403.
So had you complied within the 30 days, because in this instance it was unrealistic, as my colleague suggests, maybe under our rules to be able to get that relief, you say in your letter, if you don't get it in 30 days, you don't obtain it in 30 days, we're going to remove the restrictive covenant. Doesn't that end the analysis?
I don't think it does end the analysis. It may have if we had done it within the 30 days. We did not because we were facing conflicting orders and the court was considering the injunctive motion, and at that point, it was an issue of whether or not we got out in front of the trial
But I think the
court.
question then becomes, okay, it says 30 days, release it. And the statute then covers you, right?
Yes, the statute, if we had released it within 30
Why not just
days.
release the restriction?
Because we didn't know for sure who owned the
Yeah,
shares.
but it doesn't matter to you. All that matters to you is that you're not liable. So if you release it and the statute covers you, just release it.
Well, I wouldn't disagree that if we had released it, the statute would insulate us
So
from
then
liability.
why not do that when the statute says it and you agree that you'd have no liability? Your position is, I get to not do it and still not be potentially liable, right?
Well, our position was it was under these specific set of circumstances not unreasonable for us not to.
So then you became the arbiter of,
Well, that was our concern. My
But
client's
under
concern.
Delaware
was-
case law, is that something that you should be involved in? There's a dispute certainly between the plaintiff and defendant. You're just a mere agent in there. You're a transfer agent.
That's
And
correct.
The courts seem to suggest that they don't really want the transfer agent making these decisions between the parties.
We were effectively in the position of somebody in an interpleader where we were holding on to something of value that we made no claim to, and we didn't know which side.
So that's what I don't understand, why you just didn't release the restriction, because you knew you were covered under the statute.
Well, I don't disagree that the statute would have insulated my
So
client, but
then,
we didn't do
because
that,
you
and now we're in
didn't
that world.
do that, then you have potential liability. And if your defense is, well, it wasn't unreasonable, there's no possibility of deciding that on a motion to dismiss.
Well,
right?
there's never been a single case that has held that a transfer agent under these circumstances under Delaware law would be liable.
But also we couldn't find a case where someone was dismissed out on those grounds either, right? Figure it out.
Correct.
Let's see if
That's
it
correct
was
as well.
unreasonable.
Thank you, counsel.
Thank you.
Counsel, I have a minute.
Thank you. Your Honor, on the topic of unreasonableness, which Mr. Brown mentioned earlier, unreasonableness is not appropriate as a question for a motion to dismiss, and that's precisely why we should not be dismissed out at this stage. If we want to talk about unreasonableness under 8401, assuming that's a general standard of unreasonableness, that should be down to a more ultimate determination, for example, at summary judgment or at trial. Another point, Your Honor, is that to take note of is that the court actually at the January 19 hearing, which I mentioned earlier, January 19, 2022, actually questioned TransShare on why precisely it hadn't removed despite there being no TRO in place. So that does indicate to you that the court at that time, which was presiding over the TRO and preliminary injunction, was curious as to why TransShare had not proceeded to remove the restrictive legends despite the lack of injunctive order having been made. And one more point, Your Honor, which is that just taking a step back from the 30 days that we're talking about, there is another basis on which, and in fact, maybe even a more direct basis on which my appeal should be granted, and that is that Shineco in the first place was not even the proper party to make a demand under Section 8403 of the UCC. Under Section 8403 of the UCC, only the record named shareholder is the appropriate person to make an effective demand under 8403. That can then play into the preconditions under Section 8401A6. So seeing as Shineco in the first place, as a very fundamental matter, was not even an appropriate person to make an effective demand, there was no effective demand to even kickstart that 30-day process. So what happens in that case is that when my clients presented their certificates and requested for registration or transfer, what should have happened rightly would have been that TransShare should have immediately just, even without that 30-day process, honestly, just released the restrictive legends and allowed them to be free trading shares. So that's, I think stepping back from the 30 days, that's the most important point, Your Honor.
Thank you very much, counsel.
Thank you.
Okay, we're going to take a pause while we remove some equipment. It's moving up and not down. Yeah, got it. Okay, People versus Foreman. You may proceed, counsel.
Good afternoon, Your Honors. Nathan Brown on behalf of Appellant Thomas Foreman. The lower court erred in denying diversion into a drug rehabilitation program here, where the evidence before it militated in favor of diversion, including a statutorily mandated psychiatric evaluation, which recommended diversion and found that significant mental illness was unlikely.
So your position is that the lower court abused its discretion, not necessarily that they had to place its reasons on the record? Or
It
is
did have the
both?
requirement to, exactly both, Your Honor. They had the requirement statutorily to place its reasons on the record so that when we're doing this, we can understand what it based its decision on. We don't know here, and the evidence before it was, like I said, it was very strong in favor of granting diversion, but very
Is there an
weak.
issue with preservation here?
There is, Your Honor, and we would ask this court to exercise its interest of justice power given the fact that Mr. Foreman was...
Okay, so let's look on the merits. On the merits, had the defendant ever successfully completed a treatment program outside incarceration?
There's no evidence that Mr. Foreman was ever in a treatment program for the purpose of rehabilitation.
And in fact, isn't it correct that he violated his probation a couple times, and that was a reason why the diversion case manager did not believe that he was an appropriate candidate for this? Is that
The record actually doesn't say that the diversion case manager thought that his violation of probation was... That's one of the problems with the evidence here. The probation says that the judicial officer said violation of probation was a basis, but the judicial case officer said that his violation of probation was a reason. So,
but isn't that a reason? Isn't that a fair reason, irrespective of who said it, probation or the case manager?
Yeah, I mean,
Violation of probation suggests that maybe there's a problem with complying with rules and the like.
I think that why the violation of probation is not a significant factor here in denying is because this court, the Court of Appeals, and the statute itself contemplate that relapse is a part of the recovery process. The statute recognizes that a criminal history, one that suggests an addiction to drugs, is a basis for going into a diversionary program, not a...
And in fact, he was self-reported that he had been in a program about 2 years, but then less so in the 2 months prior to this particular incident, suggesting that there was in fact a relapse.
Exactly, Your Honor. Well, so two things. It does suggest that he was relying more heavily on the drug that he was addicted to, but also I think the record doesn't give us reason to believe that his participation in those methadone programs were necessarily rehabilitation focused. And so I don't think that they demonstrate a prior attempt at rehabilitation, but I think they do demonstrate an increased reliance on his addiction prior to this offense.
I mean, I want to focus again on the abusive discretion standard, right? Because the lower court, even though that court did not list all of the reasons why he found the defendant wasn't appropriate candidate for diversion, prior to that, and I think maybe even an appearance prior to that, there has been a substantial record made from both sides. So why isn't that enough, especially under our case law? And I draw your attention to the O'Keefe case coming out of this department in 2013. Why isn't that enough?
No determination was made at that hearing where there was the primary discussion about diversion. A separate judge at a separate hearing where actually the discussion was sort of around different issues. The second hearing was based primarily around the violation of probation, and the earlier hearing focused mostly on mental health. And so I think the actual hearing where the only discussion of denial was that the court said something to the effect of, I don't think he's a good candidate for diversion, without providing any basis. And the context of that hearing separates it from the prior hearing where a discussion was entirely different. So I'll
Thank you, Counsel.
reserve rebuttal. Thank you.
You'll have a minute in rebuttal. Please proceed.
Good afternoon, Your Honors, and may it please the Court. Caroline Williamson for the people.
So, counsel, can you just address that last point, that even though there might have been a substantial record made on a prior occasion, the occasion where the judge who actually did the sentencing or the hearing, the second part of it, the probation part of it, only focused on the probation violation. So that's maybe not enough of a record for us to determine whether or not it was an abuse of discretion or not.
So even though it was a brief hearing where not every part of every factor statutorily was discussed, we think that the record also contains all of the other evidence indicating that the defendant wasn't a good candidate, because that includes his prior criminal history, which, even though not discussed, was something that the hearing court was very much aware of. The fact that he had violated probation many times, the fact that there was a dispute over whether he was a better fit for mental health court, and in particular the fact that the judicial case manager, the judicial diversion case manager, thought that he was not a good candidate. And these are all things that the hearing court was entitled to consider when making its determination in exercise of its discretion. And these are things that lower courts and this court have repeatedly said are factors that can be considered, and they've affirmed denial on that basis, particularly prior criminal history, of which this defendant had.
Did the defendant have a substantial criminal history?
He did. He had a substantial multi-state criminal history. He had at least 6 burglary convictions, one of which he served 4 years in prison for. He was repeatedly in violation of probation, both in New Jersey and in New York, including at the time he was arrested for the instant offense.
And was there a question as to whether or not diversion was appropriate because of his mental health issues?
That did come up because there had been a record mostly made by defendant himself and by his attorney that he was schizophrenic, and therefore his issues may not have been rooted in addiction, but rather in mental health issues, and he would have been a better fit for mental health court. And so there was a lot of debate in the record about that.
And he was actually sent for an evaluation for that purpose, right?
He was.
It wasn't he wasn't blowing smoke, right?
No, and he was not only sent to the to Dr. Sirik for that purpose, and the doctor did say that he thought he might benefit from, or would benefit from, in treatment in drug facility, but he also thought that he should continue his regimen for mental health. He never said to stop taking the medications that he'd been prescribed for many years for his schizophrenia and bipolar. At no point did anyone involved in this process recommend that he cease his mental health treatment. And we also do believe, just wanted to mention that there is a preservation issue with laying the factors on the record, and because the record reflects that there was ample reason for the denial, there's no reason to grant relief in the interest of justice, and so there are no further questions. Thank you.
You have a minute, counsel.
As much as I'd prefer to laud how erudite my colleagues are, I don't think defense counsel's statement that my client had schizophrenia has any bearing as to his actual...
Well, was he on medication?
He certainly was, but the record does not contain any indication of who prescribed that under what conditions. And as Your Honor pointed out, he was sent for a specific psychiatric evaluation, and that specific psychiatric evaluation determined that he was unlikely to have schizophrenia. The record is replete with misinformation about his diagnosis. In the Manhattan Drug Court...
But didn't that in part come from information he provided?
Some of it did, Your Honor, but I don't...
So there's some sense in terms, is he an accurate conveyor of information with respect to himself?
And that's one concern that we have, and why it's our position that the court would have been better off deferring to the expertise of a psychiatrist who prepared an individualized evaluation for the purpose of this determination, which said that he did not, or he was unlikely to have schizophrenia, rather than rely on this unprovenanced information, whether it was from, my client from an unknown source or not. I'd also just want to point out one clarification.
Sure.
The psychiatrist did not recommend that he continue taking psychotropic medication related to schizophrenia that he said he was unlikely to have. He said that he should continue mental health treatment because, as the psychiatrist concluded, he did have other mental health issues that were not schizophrenia. Thank you.
Thank you both. Nationwide.
Good afternoon, Your Honors. Happy holidays. I'm going to do a minute and a half just for you. All right. I just want to point out a couple things in the record. May it please the court. Alan Hollander on behalf of Nationwide. We have a disclaimer defense here of EUO no-show and a founded belief that the accident was a stage or cause loss. Just want to highlight to you the particulars. You have a no-fault
So
application.
you have the guy who's driving the car saying it's a staged accident, right?
I have it, yes.
Yeah. And then you have the two people who are injured don't show for the EUOs.
I have it.
And you have substantial treatment for a car that's not really knocked up.
Have that too.
We got it.
Okay. I just want to point out that we were timely and everything, because that seems to be what the first department is looking for, to make sure that the insurance carrier does everything on a timely basis. And I wanted to point out in the record that on page 224 of the record, we have a no-fault application received on October 16th. On pages 512, 633, and 663, we have the prescribed verification forms, which are dated 10/24, 11/6, and 11/20. And we could see that the no-fault application went out 10/28, which is within that 15-day period or before. And then we have the proper disclaimer when the investigation was concluded. Thank you very much. Have a happy holidays.
Thank you, counsel. In the matter of Amelia? You may proceed.
May it please the court, Emily Wall from the Center for Family Representation for the appellant Saul A. The evidence ACS presented at the fact-finding hearing established that the 5-month-old infant was asleep in another room while the incident took place. This evidence was insufficient to establish that the child was neglected because there was no evidence that the father's actions caused the child to be harmed or created an imminent risk of serious harm.
But isn't our case law such that we have, in circumstances where children are sleeping, have found, in fact, that there was neglect in those circumstances? So I'd like you to respond to the force used in this case. It was an assault that lasted for several minutes, correct?
Yes.
With a broken nose, severely injuring the mother. Under our case law, is that sufficient?
I don't believe so, Your Honor. The only case that the respondent cited that involved a single incident of violence of which children were unaware was the case of Najayi C. in the second department. And that case was much more egregious than this case. It involved a deadly weapon. The parent had used a knife in that case to attack another relative in the home. And so that, because of the use of the weapon, I believe that created a much
Well, why
greater
would,
risk.
isn't a fist a weapon? Or couldn't it be, under these circumstances, considered a serious weapon?
It isn't a deadly weapon like a knife. I mean, I would argue that that distinguishes that case from this. And there's no first department case that was cited to.
So then your position is only in instances of deadly weapons, and that can't be expanded on or at all?
Well, Your Honor, I would say that the only time that a child who's in another room and sleeping would be at imminent risk of physical harm or the kind of emotional harm that's required to support a finding of neglect would be with something more than just a fist fight happening in another room.
Well, it's not a fist fight.
Yeah.
This is an assault on a sleeping woman.
Yes. So there was no risk that the child who was in another room would be physically harmed during this incident.
Well, so wait. So the father punches the pregnant mom, right? And
I don't believe she was
maybe,
pregnant, but
I'm sorry. The father punches the mom. He breaks her nose. She runs out of the apartment, and he runs out of the apartment at some point too, right? Or no, he is there with the child, but he's getting arrested and there's no one there for the child, right?
So at the point where he's getting arrested, the police are there, and they're not going to leave a baby alone in the apartment.
Yeah, but it's not, but the point is, it's whether he has put the child in a situation of not being cared for, right?
Right, so there has to be an imminent risk that the child would be exposed to either physical harm or mental or emotional harm. And so he created a situation where he was arrested, but that didn't put the child in danger of physical harm or of mental or emotional harm.
I'm just wondering, I don't know how you're distinguishing, because the operative fact would be that the child is in the other room, right? It doesn't really matter if it's a deadly weapon or a fist fight or an assault that breaks someone's nose. If there is some way to transfer that, to say that that person would be subjected to neglecting that child because they're in another room, it doesn't really matter if there was a knife, a fist, whatever.
I would argue that the use of a deadly weapon is a more serious incident, and it's also more likely to create the kind of emotional or mental harm that would support a finding.
But wouldn't it, whether it's a knife or a fist, wouldn't it suggest, or wouldn't it be a fair inference to draw that the parent's judgment was strongly impaired?
Certainly, but the other aspect of a finding of neglect that's required to be proven is that the child was impaired or at imminent risk of impairment.
But it exposes the infant, doesn't it expose the infant to substantial harm based on the violence used on the mother?
So this was a 5-month-old infant, Your Honor, and I mean, if the suggestion is that she would be at risk of mental or emotional harm from overhearing this incident, I don't think we can assume what a 5-month-old is going to understand from overhearing an incident like this. There was no evidence that she was impaired.
So then why does it matter whether she's in the room or out of the room?
Well, if she's in the room, she's at risk of physical harm from the altercation. So there's...
You're saying there's substantial risk of physical harm if she's in the room?
Yes.
Okay, thank you. Please proceed.
Please, the court, Alina Drucker on behalf of ACS. I think this court should affirm, as I think a preponderance of the evidence establishes.
But what about counsel's point? You
Absolutely.
have a 5-month-old baby in a room who presumably is asleep. I guess we don't know that. What's the substantial risk of harm to that infant?
I think there are at least two ways to think about it. The first is, I think, as this court acknowledged or noted in Elijah T., which, contrary to the suggestion that there's not case law on this, there's a clear case on this. The severe act of domestic violence against the mother would lead her to go to the hospital to immediately seek treatment. The children, ages 2 and 4, were left without supervision once the father was arrested.
But that's not what happened here. I would suggest to you
It is what happened here.
Well, we don't know. Because my sense of the testimony is that maybe the infant, which kind of makes sense, was taken to the precinct. But there is also testimony from the parents that suggests that the grandmother was called. So it's not clear, and the court certainly below did not make any fact findings on the issue, correct? So I don't know if we can go on that basis. So the question is was the assault so serious that there was neglect or put the child, or the infant in this case, risk of substantial harm?
So first I'd say I think that the record is actually pretty clear that doesn't count. Supervision, the fact that the police will come and take a child who has no supervision does not constitute supervision. That is neglect. When you leave a child without any caregiver, a 5-month-old in a house with a man in a fugue state fury who was just
With the
woken
cops
up.
there, right?
What?
With the cops, the police are there?
I mean, the cops don't count as supervision for the purposes of the ACS statute. That would mean that we would never be able, I mean, the police, any case that involves lack of supervision, if the police, I mean, you're saying that the man is going, this father knows
So
he
the
has a history
father
of
is there, so
domestic
why isn't there supervision from the father?
Because
the father's in the...
Well, first, and that was my second point, which is that the father is in a fugue state. He woke his partner up, punching her in the face to the point he broke her nose several minutes. She said that she was afraid for her life. She ran out of the house rather than deeper into the house, which is really the only reason the child wasn't in the same room. She fled for her life and went to the hospital to seek care. This man was so out of control. That is not the conduct of a reasonably prudent parent, to be in that state, in a room, in a house with a child. And he says, well, the child was in the other room. I mean, this man was.
So let's say the child
fully
is outside. Would it, if the child is an adjoining apartment, would that constitute neglect based on, on the
With a
rage?
separate carer?
No,
I mean, that's the point. He is the caregiver. Once he takes the mother out of the equation by trying to kill her, he is left as the sole caregiver for this child, and he is in a state in which he has just woken a woman up and punched her to the point where she was choked her.
And there was some evidence that after she ran out of the house, his rampage continued to maybe physical objects, not necessarily.
There is some evidence. There's some evidence that he remained out of control, but we obviously don't know.
But what about
exactly
with
happened.
respect to the child? There's no evidence that there was anything.
Well, thankfully, the statute doesn't make us wait until this incident turns into actual physical harm to the child. When we see that this is a situation in which the child has been put at imminent threat of physical harm or mental harm, but here we're talking about physical harm, both in the fact that the child wakes up. This father is clearly he is out of control. That's the mother's testimony. He was in a state where he had literally no control of himself. He himself admitted, I think, that he tried to choke her. He couldn't quite remember. There was that state as the caregiver, that is in and of itself neglect. You add to that, and I think the case law is pretty clear, actually, that in an act when there's an egregious act of violence, especially in a situation like this one where you have a pattern of domestic violence before the child's birth, but you know this man knows he's going to be arrested. He knows that he is basically leaving this child without a carer because he has tried to kill the only other carer in the house. And I think that, sorry, Your Honor.
Yeah, I just wanted to ask, you said there's no dispute that the child went with ACS. Could you just, because we've also heard that the parents said the grandmother was available.
So I think the record is slightly unclear on this, but the grandmother ended up taking the child after proceeding, but how that exactly happened in the moment is, I think, unclear from the record.
And the grandmother wasn't called as a witness.
What was that?
Grandmother was not called as a witness to clarify that issue.
She was not.
Okay.
Not sure.
Thank you. Thank you, counsel.
May it please the court, Shareem Nothenberg, Lawyers for Children on behalf of the child. And I think I can clarify some of these things with respect to where the grandmother was and what the testimony established. But I first want to make very clear, which is not clear in appellant's brief, that in the context of IPV, whether a child's emotional and physical health is in danger of impairment may be determined by the very act of violence itself, even absent evidence of any knowledge by the child or impact by the child. And why is that? Why do we allow that standard? Because sometimes an act of violence is so severe that it demonstrates impaired parental judgment in the act itself.
Does that matter then, to counsel's point, the deadly weapon versus just the fist striking?
Well, first of all, I very, very much object to the notion that a fist cannot be deadly, because certainly people have been beaten to death. Second of all, this woman said, I thought he was going to kill me. She said her vision was blurred, her breathing was encumbered because of all the blood gushing out of her face, and she ran for her life. That left the child at a point where you have the baby A on the sole custody and care of a person who has just tried to kill somebody by the mother's testimony.
And that, you say, is neglect, essentially?
That is neglect in and of itself. And let me explain something else to you. The father admits that even after the mother ran for her life, he became even more incensed as he was reading her text. He says that on page 26 of his testimony. So he's even getting more worked up. And this is a child who's entirely dependent on somebody who's so worked up he has no judgment not to beat, literally almost to the point where she thought she was going to die, the other caretaker. Now, where's the grandmother? So there's talk about the grandmother, right? The testimony is very clear. Mom runs for her life and summons an ambulance. The cops and ambulance, by mom and dad's testimony, came at the same time. So the father is with the cops, and he says, when the police arrive to arrest him, that the baby is sleeping in the other room. There's no grandmother at that point. The mother says in the ambulance she made a plan for the child to go to the grandmother. First of all, no evidence that that plan was executed. The only testimony is the baby still under sole care of the dad when the police arrive. And secondly, that's whether the mom made a plan. But the dad, this is a neglect case against the father. What has the father done? The father has beaten to a bloody pulp the mother's face while the sole caretaker of this child. and put himself in the position where he's going to be arrested and there's no parent for that child. And he has not called the grandmother. There's no testimony he did anything in terms of planning for this child. And I would argue and urge this court to see that it is not prudent, it is not reasonable and prudent parenting to beat another parent to the point where she escapes for her life and you know you're going to be arrested without having first made sure you have a caretaker for your child. So I urge this court to affirm. Thank you.
Thank you.
Your Honors, I just want to make a few points. First, there was no evidence in the record of the fact-finding that the child was taken to the precinct. That evidence...
Well, but the OTR record seems to suggest that. But let's put that aside. Let's put that aside that the record's murky. But at least what your adversaries argue is in the apartment, the mother has fled for her life. The father is in no shape to take care of the child. Could that be a basis based on his violence and his inability to control himself, a basis to find neglect?
I don't believe so, Your Honor. I believe the only testimony in the record of what happened after the mother left the apartment is the father's testimony. And he testified that after the mother left the apartment, he went to check on the baby and she was still sleeping. I believe that I haven't been able to pull up my transcript yet, but I...
What arrangements did he make with respect to the child after the child's caregiver had fled?
There was no evidence that he made any arrangements. The mother testified that she made arrangements while she was sitting in the ambulance outside. However, I would dispute that the child being in the care of the police would create any risk of harm to that child. Your Honor, there must be many cases where parents get arrested while they're the sole caretaker of a child, and those cases are not neglect cases. This simply being arrested is not something that would be the basis for a finding of neglect in any case.
Thank you, Counsel.
Thank you.
Thank you all. People versus Robert Story. You may proceed, Counsel.
Good afternoon. May it please the Court, Adrienne Wells, Center for Appellate Litigation, for Appellant Mr. Story. I briefed two issues. I'm not going to touch on the downward departure issue here. I want to focus on the Factor 11 issue. The people have not proven by clear and convincing evidence that Mr. Story did have a history of alcohol or drug abuse that would heighten his risk level to the community. I want to touch on a few of those purported pieces of evidence. The 2012 infraction that he incurred while incarcerated for possession of alcohol. I want to argue that that's, first of all, not consumption. Obviously, there's a difference between possession and consumption that is
So in other words, he had
out in the
this
case
person,
law.
but he wasn't drinking.
Correct. And again, this was in 2012, which is very remote in time from the 1996 offense, so it's just not relevant.
Would you address the mass assessment where he was scored in the alcoholic range?
I will, Judge. So that mass assessment was the result of a treatment referral because of the infraction. So the referral, 2 points. First, the referral itself is not indicative of abuse of alcohol. That was a procedural mandate by corrections. Then when the mass screening took place, they did say that he was in an alcoholic range. That also was in 2016, 4 years after the 2012 infraction, and many, many years from the 1996 offense. That same screening result also said that Mr. Story had completed treatment for alcohol in 1993 and had not consumed alcohol since 1994. So even taking any of these things to be true, they're contradictory, and therefore this document, this referral, cannot meet clear and convincing standard. I would ask this court to credit the 1997 mask screening result, which was close in time. It was at his doc's intake once he was convicted for the offense from 1996.
So, counsel, wait, he had 2 previous convictions connected to drugs, right? Or alcohol?
Misdemeanor drug possession.
Yeah, so he has 2 convictions for drug possession.
Correct.
He says he did like several $100s worth of drugs right before going into prison, right?
No, Judge. There is an alleged statement that he used, that he spent some amount of money on crack cocaine, but that was in, I believe, at least 6 years before the 1996 offense and conviction.
And then he gets a Tier 3 infraction while he's in prison for possession, right?
Once in 26 years.
And you don't think, well, I mean, he's in, let's say maybe that happens because he's in prison for most, right? So, and you're saying that that isn't enough. All of that together isn't enough?
No, Judge, I don't believe it is. I think that...
Did he ever complete alcohol and drug?
I believe he had to complete the ASAT, Alcohol and Substance Abuse Treatment Program, as a result of the referral from the infraction. But again, Judge, common sense tells us all that people can get access to illicit substances in prison. The fact that this man in 26 years didn't have any other infractions for possession of drugs or consumption of drugs or consumption of alcohol, I think tells us that that's not a person that's abusing those substances.
And you don't think that all of those factors together show a risk of reoffending?
No, Judge, I don't. I think the remoteness of all of...
Well, I mean, most of the remoteness, I'm sorry, I didn't mean to interrupt you, but I'm just here to, I want to point out that most of the remoteness, except for the drugs that he was found in prison with, are because of, I'm sorry, alcohol. Well, okay, the illicit substance is because he's in prison, right?
As I said, I think somebody who actually has a serious problem abusing drugs or alcohol would probably have been cited more for possession or consumption of those substances in 26 years.
Thank you, counsel.
Of course, thank you.
May it please the court, Larry Glasser for the people. Your Honors, over a period of approximately a quarter century stretching from 7 or 8 years before this crime to 2 years after the crime, 7 or 8 years before the crime to 20 years after the crime, this defendant has 2 convictions for possessing controlled substances. He scored in the alcoholic range on the MAST assessment. He admitted to using hundreds of dollars of crack cocaine per day. He participated in 2 separate ASAP programs while he was incarcerated. And he had a disciplinary infraction for possessing alcohol.
Well, how do you respond to your adversary's point that he was incarcerated well over, I guess, over 2 decades, and there was just one possession infraction, not even consumption infraction, which counsel would argue shows that there wasn't clear and convincing evidence.
Just one in 2 decades is one more than most inmates have in state prison. And the circumstances of that, Your Honor, are that he admitted that he possessed it, and he did not drink it, he did not consume it, but he said he possessed it to cope with his mother's death. So I can't think of what's a clearer sign of having an addiction and having a problem than in prison where he's not supposed to have it at all. He manages to obtain some of it, which he intends to consume as a coping mechanism. That is a sign of a dependence on it. In addition, Your Honors, as the court has noted, he has been diagnosed with severe substance and alcohol disorder and an untreated alcohol substance abuse history. He himself was interviewed on how his substance abuse history affected him, and there's a checkbox list of descriptions, and he indicated it's resulted in a failure to fulfill obligations. It resulted in social and personal problems. It resulted in him consuming larger amounts than intended, and that he can't cut down despite attempts. Looking at the totality of this record, again, stretching from before this crime by almost a decade to decades after this crime, except for one MAST assessment that said he didn't have treatment, and one time he did successfully complete treatment, as we all know, as came up in an earlier case today, Someone who has an addiction may have moments of sobriety. They may have clean spells and then relapse. This defendant, if you look at the entirety of the evidence over this quarter of a century before and after the crime, it's a fairly nonstop, consistent record of substance abuse. And the only reason it does minimize slightly as we get closer to the present day is because he was in prison. And I'll note that based on the terms of his sentence, it was a maximum security prison. So rather than saying, well, he only had alcohol once in 20-something years in prison, I would argue he managed to obtain alcohol once in 20 years in a maximum security prison. And that took effort, that took intent, that took purpose on his part to obtain the alcohol, which again, he said was a coping mechanism. Taken in conjunction with, again, his criminal record, his admissions of drug use. He had a prior robbery conviction that notes in his brief involves a 14 or 15-year-old male victim. He notes in his brief that that is a drug-related robbery. He has a fairly uninterrupted history involving drug and alcohol use and possession. So if the court has no questions, I'll rest on my brief.
Thank you, counsel.
Thank you all.
Counsel, you have a minute.
Thank you. As to counsel's last point about this previous robbery that Mr. Story allegedly admitted was drug-related, the argument in the withdrawn, he did not admit that he was on drugs while he committed the robbery. He was not saying I was on drugs when the drugs compelled me to rob somebody. I would read that as because he also has these prior convictions for possession, perhaps it was something to do with being embroiled in that world, but that does not make him a consumer of those substances.
Well, but how about his admission that he consumed $700 worth of illicit substances a day?
That statement was 6 years prior to the offense. I have no context for how many days he's referring to. I have no context for how much or how often that is. I think that there's a
well,
just don't have enough
assuming he had a
information.
habit, a $700 a day habit, I mean, that suggests, wouldn't it suggest to you that it's a serious problem?
Even accepting that, Judge, I don't believe that it extends 6 years past the time he made that statement to the 1996 offense. And the purpose of these Factor 11 points, Your Honors, is to evaluate whether someone, because of their substance abuse or their addiction to alcohol, that makes them a greater risk of recidivating, a greater risk to the community. There is not a single thing in the record, a single piece of evidence that's been put forth that Mr. Story has either consumed or abused alcohol since 1994, nor that he has consumed or abused.
But the reason for that, and you know, forgive me for going over the red light, but it's for us and not for you, so you can answer the question. The reason for that is he's incarcerated. He isn't in an opportunity to be able to do it, except for the one that we know of, where he was able to get alcohol in a maximum security prison.
Again, all I can answer, Judge, is I can only restate what I said before, is that it's not impossible, as we can see, and it's common sense.
But it definitely shows some real purpose to have it, to be able to get it, right?
I think that we don't know. There's nothing in the record, and we might think that, you might think that, but I don't believe that the people have put forth evidence that's clear and convincing to show us that he has a problem with alcohol. And a bunch of crumbling bricks do not create a stable foundation.
Thank you. Well
Thank
said.
you.
Barton LP versus Maybank. You may proceed, counsel.
Thank you. May it please the court, Philip Furia for respondent appellant Alexis Maybank. We're here today asking this court to vacate an arbitration award stemming from an arbitration conducted through the New York State Fee Dispute Resolution Program. We contend that the arbitration panel exceeded its authority in conducting the arbitration and in rendering the award. The arbitration in question was governed.
Tell me, sir, you on the eve of the arbitration hearing, you assert malpractice. Was a claim prior to that time ever filed?
No, Your Honor. And
so why wasn't the claim filed?
I would disagree with the contention respectfully that it was done on the eve of the arbitration. The timeline shows that the arbitration notice was sent out on October 14th for an October 28th arbitration. I was retained shortly thereafter. On October 20th, 8 days before the arbitration and 6 days after the notice came out, we made the panel aware that Ms. Maybank's defense, apologies, Your Honor.
To interrupt you, but I just want to make sure I understand, because you said that the notice to arbitrate wasn't sent out until October 14th. I thought it was sent in July, July 27th.
The arbitration was initially requested, and there was a lengthy procedure, which I guess was governed by the New York County Lawyers Association, where they were attempting to go back and forth to try to mediate the issue. But the actual arbitration notice, the one that governed this arbitration, where I was retained and brought in to do the arbitration, or potentially do the arbitration, is dated October 14th, and it's in the record.
So in other words,
No, that can't be, because they went in on August 17th for an arbitration, which turned out was converted into a mediation, right? So it can't be that your timeline is correct. The parties went in, and they on August 17th. That was the day that the arbitration was scheduled to begin, and then they decided to mediate, correct?
Correct, but this arbitration, which took
But
place...
this arbitration is started with the first arbitration notice.
And, Your Honor,
And
if
then
we,
when
even
the
if we...
mediation wasn't successful,
Right.
it was converted back to arbitration, and that's when you come in.
Right, that's when the notice was issued, October 14th. But again, we send our letter. 8 days is more than enough time for a letter to be read. The letter made it clear Ms. Maybank intended to defend herself at this arbitration by saying that the fees owed were not owed because of the negligence on the part of the attorney.
And what was this alleged negligence that you were asserting, sir?
Now, this negligence was asserted in the letter. We gave several examples of the negligent activity. This included that counsel engaged in excessive delays in pursuing
One
the case.
second, may I interrupt you again? Okay, so then August 25, there's a letter to the parties saying, I'm scheduling this for October 3rd. Between August and October 3rd, does your client assert any malpractice?
No, Your Honor.
Okay. Then she asked for an adjournment, right, to October 12th. Then between the time of October 3rd and October 12th, does she assert any claim of malpractice?
No.
And then she asked for another adjournment from October 12th to October 25th. During that period of time, does she assert any claim of malpractice?
Yes.
Oh, yeah? What does she do?
On October 20th.
Okay. So, and you're retained on October 18th. So that is exactly the point. This has been going on for several months before she retains an attorney, and for the first time, right before the scheduled arbitration date, asserts a claim of malpractice.
She retained an attorney to represent her at the arbitration, and as her counsel, we together planned to present the defense that the fees were not owed because of malpractice. That's Hornbook law in this state, that an attorney doesn't get paid fees for work that's done negligently.
But then, again, counsel, why didn't you timely assert a claim for malpractice? Given the period of time, I understand that you want to focus on the time that you were retained, but it seems to me that the entire period counts against your client.
Your Honor, and I understand that may be a position that could be taken. I suppose that's some form of a laches defense. That was not part of the briefing here. What was argued here was that this fee claim is intertwined with the malpractice claim, and that was never disputed. So either that matters or it doesn't. If this court is going to sua sponte determine that it was asserted too late, that's unfortunate.
Well, the question is, why don't you sit down and we'll hear from your adversary now.
Pardon me?
You have the red light, so why don't you have a seat? We'll hear from your adversary, and you will have some rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. Orit Hershkovitz on behalf of the respondent, Barton LLP. Your Honors, there was no claim. There never was a claim.
Well, that's what I was getting at. Was a claim for malpractice asserted in any fashion, including the letter sent by counsel?
The answer is no.
Why?
As Why? Because there was no malpractice committed. That's
Well,
ultimately
that's a
the
separate
reason
issue.
why.
It was a claim asserted.
As appellant's counsel himself articulates in his own brief, there was an accusation made of malpractice. There was never a claim filed. There was never a cause of action filed. To this day, nothing has been filed alleging malpractice.
Counsel appeared at the arbitration, correct?
Appeared,
Did
yes.
counsel assert any claims of malpractice at that time?
I don't believe so. There was no defense presented.
Well, that's presumably because they had indicated in their letter that there was malpractice and this shouldn't go on, and so maybe the position was taken that we're going to appear, but we're not saying anything. Right? Isn't that what happened? They had sent a letter saying, we don't think that, please cancel the arbitration. There's been some legal malpractice here, but to preserve my client's right, I'm going to appear. Wasn't that the circumstance?
You'd have to ask counsel, but yes, they appeared, but she didn't testify. I don't recall any argument, any substantive argument being made. So they simply appeared to hear my testimony.
Well, but arbitrators can't cure malpractice. I mean, we understand that.
That's
right?
correct.
The rules clearly
That's
provide.
correct, but there was no dispute on our claim for unpaid fees.
Well, that's because they can be separate matters, right? There's the subject of fees on the one hand and the subject of malpractice on the other.
Correct, correct. And if there were a properly filed malpractice claim in this court, that would have been heard.
I guess, let me ask you that. There's nothing to stop the claimant from suing for malpractice, right?
Absolutely not.
Right.
No, and
Okay.
she hasn't.
Right.
It's been over 2 years since our representation was terminated, and nothing's happened. We've been waiting to be paid a very long time. And we respectfully request that this court uphold the lower court's determination, confirm the arbitration award, and dismiss the appeal.
Thank you.
Thank you.
So, Your Honors, on reply, I want to make the court aware of the serious public policy concern at play here. And I think it's enough to win the day. Normally, a fee arbitration is subject to de novo review. So it's not terribly serious if you go in there, you lose, you can just have it reviewed. Here, the retainer agreement says that the client waived de novo review. That's allowed, right or wrong, it's allowed. So what we have
Counsel,
here
is there anything stopping your client from bringing a malpractice claim?
there is nothing stopping her from bringing a
So
claim.
what is the problem?
The problem is that because she was not allowed to ask for de novo review, the situation was set up that counsel, who's accused of malpractice,
She contractually agreed not to that.
I understand, but she contractually agreed to arbitrate pursuant to the Part 137 rules. And in this situation, counsel is accused of malpractice, can go to an arbitrator, obtain an award, get a judgment, and do this all expeditiously while requiring their client to go through the much slower litigation process. And
But even if you had, counsel, it seems to me that even if you had filed a claim for malpractice, under our case law, what probably would have happened is that the malpractice case would have been stayed, arbitration would have gone forward, and Protostorm is the name of the case that I'm reminded of, and then there would have been a result, and we would have come back. So again, file your claim for malpractice if that's what you have.
Again, I just want to make one more point. I see my time is up.
Absolutely.
Point is, if this court allows this to happen, every single lawyer in the state is going to amend their retainer agreement to say that the client waives de novo review. Because if they do that and they happen to commit malpractice, then they can just go to an arbitration, get a judgment, and advance very aggressive judgment enforcement techniques to put pressure on their client.
And the converse is also true. That if we find the other way, and I'm not sure where we go with this case, that it's a field day to assert frivolous claims of malpractice, so you don't have to go through the arbitration process that was agreed to in the first place. In any event, that was a statement, not a question.
Thank you, Your Honor.
East 54th operating. Whenever you're ready, counsel.
Thank you, Your Honor. Good afternoon, Your Honors. Jeremy Honig from Rifkin Radler for the appellant East 54th Operating LLC. Supreme Court granted the landlord in this case the extraordinary remedy of a mandatory injunction requiring my client.
Well, what do you think we should do?
What I think should have been, what I think the court should do now is reverse, and because the landlord did not satisfy the requirement for mandatory injunction. In the alternative, Your Honor, if it's not a reversal finding as I just stated, there needs to be a hearing on the factual issues as to whether my
And what are the factual issues raised here, sir?
The factual issues, Your Honor, are whether my client, the tenant, is required to fully vacate the garage for a period of at least 4 months while the non-emergency repairs are taking place.
Well, you say non-emergency. The architect certainly, for the owner, believes that the repairs are serious. There's some serious issues.
The landlord's engineer never said that these are emergency repairs. As a matter
Is that what you're requiring? Is that what we should require, that the building's going to collapse tomorrow?
Oh, no, absolutely
So
not,
doesn't-
Your Honor.
Right?
We-
So, I mean, the fact that the building's not going to collapse tomorrow doesn't mean that it might not collapse during the 2 years that you're litigating who has to pay for this, right?
Well, Your Honor, there's a couple of things about that.
So
There's a procedure that the DOB follows under the local law.
Okay,
The
we've just had several garage collapses, right? And we assume that the DOB was following all their procedures during those garage collapses. But let me go back to the question of the hearing. Is your position that the lower court should have held a hearing so that you could put forth, because the expert that you were able to put forth didn't address some of the things that the landlord's expert.
That's not the case, Your Honor. And I do think that I should inform you of a change in circumstances that has happened since the briefing.
Wait, is this outside the record?
It's outside the.
Please don't. Just stick with what we have, because we're not going beyond the records. Okay. So it's your position in a nutshell that there should be a hearing as an alternative position.
As an alternative position, our engineer set forth in the affidavit that these are not emergency repairs. And the reason we know these are not emergency repairs is because a few things. Number one, they've admitted they're not emergency repairs. If you look at the record, there is a notice from the managing agent of the co-op that is dated less than 2 months before they move for this emergency injunction that tells their own shareholders, you can continue to park there. Do not worry, this is not an emergency. The DOB has not issued any violation.
So let me ask you, under the lease, they have the absolute right to go in and do these repairs, right?
They do not have the absolute right.
So long as they don't, it's right, there's like some sentence, so that in the least restrictive way or something like that.
What it says is, and this is identical to the case that this court just decided in April, 116th Street Laundromat. What did
we do? We sent it back for a hearing.
We sent it back for a hearing to harmonize the landlord's right to do repairs with the obligation to take good faith efforts not to disrupt.
So isn't that your primary position here, counsel, that there should be a hearing? And
no, the difference between this case and that case is that they didn't meet their initial heightened burden of showing irreparable harm.
So what are you going to wait for a collapse and a car to go down and people to die to say, well, now there's
Your Honor, there's nothing in the record from anybody, their own expert, saying that that's even a consideration here. That is just a fabrication.
Okay, we'll hear from your other side to see what they have to say about that.
So I'm going to start you out. Are these cosmetic repairs that we can do anytime, no problem, no issue?
No, Your Honor. According to our engineer, Mr. Buchanan, I mean, they're clearly not cosmetic. And I just want to make sure the court understands that our folks didn't walk through the garage and just on a hunch decide that, we should just close the place and, demolish this, demolish that, just because we feel like it. There was a complex scientific analysis done. There was coring samples taken from the garage that showed sodium chloride entering the concrete substrate at a level.
But respectfully, that's not the issue. I understand that repairs need to be done.
Sure.
What your adversary and what his expert says is that it can be done in stages. You yourself said it can be done in stages. You can close one ramp off one street, et cetera, et cetera. So why shouldn't there be a hearing for the court? Because this is granting of a mandatory injunction on a preliminary injunction, the whole ball of wax. Why shouldn't there be a hearing on these issues?
Well, a hearing on these issues is not necessary, and it's shown by the case that they rely on, the 116 Laundromat case. Now, in that case, the lower court did not review the type of things that Judge Bluth at the lower court here reviewed, namely the fact that the undertaking that was set is the exact amount that the tenant...
Forget, the question is, you have an obligation under your lease. You may do your repairs, but you have an obligation under the lease to do it in the least restrictive way. And the tenant has at least put in enough to raise an issue of fact as to whether a mandatory injunction shutting the garage down for an unlimited amount of time until you decide the repairs are done complies with that lease obligation, right?
Yes,
So
Your Honor.
why not send it back?
Well, the standard under the lease is an unreasonable interference with the tenant's
And
business.
the tenant put in an affidavit from an expert that said that this is unreasonable.
The affidavit from their expert does not make that statement because they did not review the
But isn't this the suggestion that the repairs might take some couple of months or something like that, so when they would not be able to operate their business? It's a garage. So how is that not unreasonable? A couple of months, not weeks, not talking days, we're talking months.
We are talking months. However, the lease contemplates a total closure of the business, frankly. There's a provision in the lease.
Well, where would they park the cars if not inside the garage?
Well, they're going to have to tell the folks, the customers that they have to take their cars out of the garage. That's how that would have to work.
That would be a complete shutdown of their business.
Temporarily, Your Honor. And, I think the court has to keep in mind that the lease itself contemplates this because there was a rent abatement provision that was negotiated between the parties that established a formula whereby the tenant would have a rent abatement according to how many spots they lose if the landlord does repairs under the lease. Now, we dispute that they're owed money under that provision because there was recently a renegotiation of it that carved out work to the ramps of the garage. However, we're willing to post a bond in the exact amount the tenant is asking for in order to get this work done. Again, the work has to be done.
But again, counsel, I guess I can't get over the fact that you have Massetti saying that the work can be done in stages except for a portion of the time when a slab has to be replaced. Then he acknowledges that the garage has to be closed. It doesn't seem unreasonable to me that the tenant be able to put that argument forward to the court, and the court then will hear both experts and then make the determination that the court's going to make. What's wrong with that scenario?
Well, what's wrong with it is that the Massetti affidavit does not say anything with regards to key factors, key risks that we're trying to minimize, like the collapse risk to the garage. There's no mention.
Okay, so let's, if we want to go down that road, was there a declaration that the garage was unsafe? Just yes or no?
No, there was not.
So what inference do we draw from the fact that your architect reviewed it, found it, that there was nothing unsafe about it? Does it suggest that it was safe but needed repairs?
Well, what the engineer said, Your Honor, is that the garage is in a current and ongoing state of deterioration, and that the repairs should be done now to avoid further.
So in other words, it's safe now, but it needs to be repaired. So which is the intermediate ground, correct?
Well, we reject the notion that we have to, again, like the court mentioned, that we have to wait until the eve of this place.
I'm not suggesting you have to do that. The only issue is whether it can be done in stages with their business operating or not.
Well, again, if you read the Pecanis affidavit, it's very clear that there cannot be a business running while there.
Except one expert says there can. You might not agree with that, but we're not here to make that determination.
But that expert did not address the risks that we are entitled and obligated to minimize.
And isn't that a great argument to make at a hearing as to whether or not a total, I mean, you're talking about a mandatory injunction that has no end date, right? That's what was granted.
Well, no, in terms of an end date, it does have an end date.
In terms of?
Our folks have had an upper limit on the estimate of 4 months.
No,
So
for you, but the court's mandatory judgment doesn't say it is closed for 3 weeks or 2 months or 3 months, correct?
and that's because we have to finish the work. That's
exactly. So it is a mandatory injunction, full injunction, what you are ultimately seeking with an unlimited, at this period of time, end date, right? With no hearing.
I wouldn't characterize it that way, Your Honor, respectfully.
Okay.
I really
Okay, thank you, counsel. Thank you.
Thank you.
Okay, you have a minute, sir.
Thank you. Your Honor, that's exactly how I would characterize it. The work, they estimate it could take 4 months. We know what happens with construction in Manhattan. Anything could happen. My client's business could be closed down for 6 months, 8 months, and
Well, the suggestion is that you have relief under the lease, maybe not.
If landlord would agree to that relief under the lease, we may not be having this dispute right now. But they're not agreeing to that. They're claiming that we're not entitled to any of it. But it stands that we have one expert saying it has to be done with the tenant vacating. We have another expert saying, no, it can be done in stages. That is the perfect time to have a hearing. The mandatory injunction here, it upends the status quo, which is not the purpose of a mandatory injunction. It grants landlord the ultimate relief on its counterclaim, which is
Although doing nothing and letting the litigation go forward for 2 years is equally, right?
There has been something done. The shoring is in place. My client gave up 135 spaces. There is 0% chance of collapse now because since this was briefed, the shoring's been done.
Okay, again, we are not going to consider that, counsel, and please, that's out of line to tell us what's not in the record, okay?
I understand, Your Honor. Thank you.
Appreciate it. Okay, next case for argument, Continuum Energy Tech. You may proceed, counsel.
May it please the court. Stuart Wells from the law firm of White and Williams on behalf of the appellant Iron Oak. We're here today seeking a reversal of a decision in order that vacated 2 confessed judgments upon a motion for summary judgment filed by people representing the interest of the judgment debtor and an alleged creditor for which there was no proof in the record to establish that he was a creditor. The movements in the motion below moved to vacate the judgment solely on the grounds that it failed to comply with the specificity requirements of 3218, which long-established rule says the judgment debtor or anyone akin to the judgment debtor does not have standing to make. The argument there is that the judgment creditor, the 3218 statute is intended to protect innocent creditors.
But isn't the affiant here a creditor too? I think he claimed
There's no proof of that.
$2.3 million.
Your Honor, again, this is a motion for summary judgment. There was no admissible evidence submitted to establish that he was a creditor, as we pointed out in our papers. There was an email from an accountant setting forth a schedule based upon review of records that are not part of the record on appeal or not part of the record below. Moreover, that creditor is an insider. He is the managing member of the judgment debtor, and he signed the confession of judgments. So he is not the innocent third-party creditor.
You entered them at that time, correct? So we're now talking about they're seeking to vacate them years later.
Correct, Your Honor. We entered the judgments in One was entered in May of 2017, and the other was entered in May of 2018.
So now, 5 years later, the affidavits are no good that are supporting the confessions of judgment?
Correct, Your
That's
Honor.
the argument, 5
What-
years later.
No, the confessions of judgment, the affidavits of confession of judgment would have expired, but they in fact were entered.
Right.
So they took effect.
Right.
And judgments were entered based upon them, as is permitted under the law, and importantly, it was as permitted in the documents itself. The letter agreement of 2018 permitted the immediate filing of the $15 million confession of judgment, a fact that was in order disregarded by the court below, prompting another grounds for reversal. In fact, we submit that the respondents in this case had absolutely no standing to bring the motion. The court recognized that. They recognized the established case law establishing that position and ignored that case law in finding and vacating the judgment, granting summary judgment, vacating the judgment. I should point out,
Do you know, I'm just curious, was the judgment debtor represented by counsel at the time those confessions and the affidavits were drafted?
there are multiple counsel involved at the time, Your Honor.
So it wasn't, an unrepresented defendant or a person who just signed a document and didn't look at it.
Exactly, Your Honor, and that goes to my latter point. There are two issues. There's an issue of fraud here, that they were fraudulently induced to
Well, I
enter
mean,
in
we're
that.
not dealing, but those are still exempt,
Exactly.
right? Right.
Exactly.
Okay.
And the fact that if he was unrepresented or the representation was compromised as part of the fraudulent scheme was not an issue that was properly presented below, was not an issue that was decided below. In fact, the court itself recognized that the issue of fraud was premature and they had a long way to prove their case. And my counsel here acknowledged twice in the record that the issue of fraud was not before the court below at the time of the motion for summary judgment. So we respectfully submit that the court should not have ignored that established case law, should have denied the motion out of hand, and that the confessed judgments, the decision in order vacating them should be reversed, and the confessed judgments should be reinstated.
Thank you, counsel.
Thank you, Your Honors. May it please the court, Gabriel Berg of Robbins Kaplan. I'm going to pick up on standing. He's got it absolutely wrong, and so does his brief. When you move by motion within a confessed judgment case, the debtor has no standing. This is what I'm going to read from his case. Generally a person seeking to vacate a judgment entered upon the filing of an affidavit of confession of judgment must commence a separate plenary action that seeks that relief. Debtor has standing once they...
But isn't there a case law which supports the position, the County National Bank, Gerlich, all those kinds of cases which seem to assert that the purpose of this is to prevent collusion, and your client, Mr. Preston, is not one of the parties that's entitled to make these arguments about his own affidavit?
That's correct if you move within that confessed judgment case. You start a plenary action, and you are not limited by that.
That's not what the case law says. If you look at cash and carry,
Yes. I'm looking at cash and carry here.
right? It stands for the proposition that the debtor, the judgment debtor who executes the document, doesn't have standing to challenge it later, right?
No, because I'm going to quote from cash and carry. Defendants may challenge the judgment by confession only by trial in a plenary action and not by motion. There's no limitation on that whatsoever. And to Your Honor's point, our client was a creditor, individually a creditor. There is proof in the
Did
record.
your client sign the affidavit of judgment by confession?
Yes.
Was he represented by counsel at the time?
He was not. Look at the confessed judgments. CET, a corporation, has no counsel listed on the confessed judgments. The second confessed judgment, the same law firm, was for the plaintiff and for the defendant.
And did CET ask for separate counsel?
No. The advisor, their client, was a legal advisor. He was putting his own interests ahead of my client's, taking advantage and collecting $30 million from my client based on confessed judgments that his client recommended my client sign as legal advice.
And 2017 and 2018, they were entered as judgments. So they've been judgments for 5 years.
And the fraud was discovered in 2021. I want to address it. It's a great point. A plenary action filed with claims for fraud, breach of fiduciary duty, and declaratory judgments on fraud and breach of fiduciary duty is a 6-year statute of limitation. That's why
Fine, your claims, your fraud claims are preserved. You can assert your fraud claims irrespective of what we do with this motion, correct?
No, sure, my claims go on, for sure, but the declaratory judgment claim, if reversed, he's going to go out and try to collect more of this fraud on my client. He has $30 million. He's not entitled to a penny. Look at the confessed judgments. They don't support the facts. They're completely inconsistent with what was going on. It is not a matter of standing. We do have standing. It's not a matter of timing.
So the court below found you didn't have standing, right?
No, he did. When he said, I am granting the motion in this plenary action, he was persuaded, as I'm trying to do now. If I read his brief, I would think what you thought. However, when the court said, I am granting this motion in this plenary action, what he was saying was, you have a plenary action, you have claims for declaratory judgment rooted in fraud, rooted in breach of fiduciary duty. Yes, you have those 2 other claims for fraud and breach of fiduciary duty. They're timely. It's a plenary action. You have standing because he's a creditor also, Mr. Preston individually, CET, unrepresented by counsel on the form, represented by the same lawyer. As a matter of public policy, do we want lawyers on the same side as plaintiff and defendant? There is no consideration whatsoever in either of these confessed judgments. The consideration is duplicated, and suddenly we have a $4 million judgment and a $15 million judgment. If your honors look closely at those confessed judgments, it's the same consideration. It is the absolute same consideration. And so the risk here is...
So your concern is enforcement?
One of my concerns certainly is enforcement. But, of course, but one of my bigger concerns is...
Well, if your concern was enforcement, how many years did you wait? You waited 5 years? Why didn't you, the minute the confessional judgments were filed, why didn't your client, Mr. Preston, do something about it?
It's a very good question. He didn't know he was being duped. He did not. He hired new counsel, and new counsel uncovered this fraud. It spans from Texas...
Wait, I thought he didn't have counsel.
No, me. I'm sorry, when he hired me in 2021.
He didn't have any counsel, any legal advice between 2017 and 2021.
Yes, from his client, who's the one putting his
You're
own...
saying counsel was conflicted because counsel was representing both sides of the transaction.
Counsel, there's a law firm, LeClaire Ryan, which is now in bankruptcy. His client was a legal advisor who hired LeClaire Ryan, and LeClaire Ryan did whatever his client asked him to do. And so they ended up on the same pleading as in the second judgment as counsel for plaintiff, counsel for defendant. In the first judgment, we have counsel for Iron Oak is LeClaire Ryan. CET is unrepresented, a corporation, unrepresented, in a confessed judgment. That's why, I know I'm...
No, finish up. I'm going to give you a minute. Just finish up. It's the only chance.
That's why, excuse me, that's why it's so important that this case be affirmed, because there is a separate last point to make here. This is a fraud on the court. When you go in on a confessed judgment, it's a rubber stamp. And right now, this court could affirm solely on the substantial interest of justice. A judgment 10 years, 20 years old, once you figure out it's a fraud, you can always undo that.
Well, I mean, yes, except no one's ever said anything about the judgment being a fraud except now in your complaint. There hasn't been a finding of fraud. There hasn't been any discussion of fraud. So I don't know that we could possibly say, sure, we're going to 5 years after this judgment was entered, we're going to vacate it in the interest of justice because someone has claimed fraud.
Well, no, hang on. One thing to respond to that, please. There was a finding below that a LeClaire Ryan lawyer put in an affirmation, and he said, the debts are due. That was a fraud, and I'll tell you what the court said. based on what he reviewed of that evidence. It was untrue, and in fact, Mr. Preston.
But those claims are preserved. You can assert those claims. I'm just suggesting to you that, I think it was Casey who put in that affidavit, that that's sort of, it's not necessary under 3218.
Last word.
Last point, and then please.
I'm sorry. I appreciate all the time. That attorney, Mr. Preston's never met him, never talked to him, never once. And the court below said the affirmation of Mr. Case is seemingly false.
Thank you. You have a minute, sir.
Thank you,
I'll give you 2 minutes since your adversary.
So I want you to address, please, the argument that because this is a plenary action and not the action within the confession, that the move-in has standing.
First, Your Honor, the existence of a plenary action does not magically create standing. Standing is a concept that a person has been injured by the actions of the defendant. In this case, as this court has pointed out, 3218 is intended to protect innocent third-party creditors. Mr. Preston, CIT, do not qualify. They do not fall into
What
protected
do you say
people.
to counsel's argument that he was unrepresented when he filed the confession? I thought you told me he did have counsel.
He was. It's not true at all, Your Honor. In fact, in the record are the two
But was
agreements.
the counsel conflicted? Or was it the same person from your firm? Because I think that's the
Their
representation.
contention, it's part of their overall fraud picture, which, as the court has pointed out, they can still maintain, and the court can make findings of fact as to whether, in fact, the conflict created, there was an actual conflict, whether the conflict created an injury, whether or not there were other attorneys who reviewed it, whether or not they were fraudulently induced to, and whether or not it was fraudulently filed. Those are all claims that still exist, so they have relief. The question here solely is whether at the early stage of this litigation, the court was proper in granting summary judgment that vacated 2 confessed judgments. I'd like to go back to 2 points. With respect to whether or not the commencement of a plenary action magically creates standing, the very case he cites, the Regency case and the Baltasar case, as we cite in our papers, both found that you can maintain a plenary action for fraud, but you cannot again challenge based upon deficiencies under 3218. With respect to enforcement and why they've waited 4 or 5 years to commence this action to vacate the judgment, I'd like to point out in that interim, Mr. Preston signed 2 other judgments affirming and ratifying the underlying debt. He signed an agreed order that was submitted in Texas, acknowledging the debt for the express purpose of collecting it.
Could the plaintiff here seek a stay of enforcement on the confessions of judgment while this plenary action is being litigated?
He can go down and do that, and we'll make our arguments and oppose that. Thank you, Your Honor.
Thank you both. Thank you. SRS Enterprises versus Rosemex. You may proceed, counsel.
Good afternoon, Your Honors. The lower court erred in its brief decision denying the motion to dismiss the complaint. The lower court, in its very brief decision and order, stated that the malicious intent element is operative here and therefore was sufficient for the second and third cause of action, tortious interference with business relations and abuse of process, respectively.
What was the purpose for the filing of the liens? Was it to achieve a collateral purpose, to blackmail or bad faith, or was it because they believe that they put materials out there and they're looking to get paid for those materials and your client's refusing to pay those materials in accordance with the lien law? Which one is it?
Your Honor, the liens were filed for their proper purpose, the allowable purpose, as stated by the lien law, which is to secure the economic interests of the lienor.
So is it the amended lien that you're complaining about? You're complaining about the second lien? Is that the issue?
Sorry, the
He's the other way. He wants us to dismiss.
I might get the wrong guy. Go ahead. I'm sorry.
Your Honor, just to
You
clarify.
are arguing that we should have dismissed
yeah.
the tortious interference.
Yes, that's right. In case that was not clear before, I do apologize.
Right, because your argument is, at a minimum, we had a business purpose for filing the liens, right?
Exactly. My clients furnished
And
materials
it
to the
wasn't
property.
paid, you weren't paid, and
Correct.
is there any dispute that you weren't paid?
There is a dispute as to the amount on the lien. Initially, before the motion to dismiss was filed, a year prior to that, the respondents filed a motion or filed a special proceeding before Judge Tisch seeking to discharge one of the liens, claiming that the liens were defective, both liens. Judge Tisch denied the respondent's request, claiming that the lien was proper on its face, and that the second lien filed was a correct amendment to the first lien. And as to whether the amount is proper, that's an issue for the underlying case.
What about when presented with the clerk's memo or the clerk's document indicating that the clerk's office was treating mechanics lien B, we'll call it number 2, because is it amended or is it a separate and independent lien created a new burden for plaintiff, particularly with respect to its relations with the folks on the main underlying project?
Your Honor, that's a good question. It has always been the appellant's position that the second lien was filed specifically to amend the contents of the first lien, and the second lien was filed as a proper amendment. What the clerk says in the clerk's memo obviously was brought up before Judge Tisch, and Judge Tisch obviously rendered a decision saying that the second lien or the amended lien was proper on its face. So it was filed for, the liens were filed for their specific and allowable purpose. There's nothing in the complaint that, with any factual support, stating otherwise. And instead, they provide conclusory allegations stating that the lien was filed to disrupt or interfere with a business relationship that it had with this other party. Now, the complaint, as well as the affidavit submitted in opposition to our motion to dismiss, is very inconsistent. They say that there's a business relationship with the property owner, and then it says the general contractor, and then it says the subcontractor. It's very unclear, causes a lot of confusion. They don't even know who the actual party is with respect to this quote-unquote business relationship.
Finish up, counsel.
Thank you.
Counsel, you may proceed.
Good afternoon. May it please the court, Leo Bronstein on behalf of plaintiff respondent SRS.
So the question, I asked the wrong party. The question was meant to be addressed to you. Is how is the filing of a lien, amended lien, second lien, however you want to characterize it, how is it done to achieve a collateral purpose, seeking to extort you, or bad faith? It's done pursuant to the lien law. They're claiming that they're owed for materials, which is standard practice in New York.
Sure, but see, the issue is that this amendment, everybody agrees that it was supposed to be filed as an amendment. Sure, it's for the same exact amount of work, exact amount at issue down to the penny. The fact that it wasn't filed as an amendment and didn't follow the procedural requirements for it to be an amendment and ended up being a second lien, we can only call it a second lien, which is what it is. The damages requested are just a solo amount in each of the liens. So
the lien law doesn't permit successive liens?
So successive liens are in the circumstance where work was performed, party wasn't paid for that work, and then continued to work, and so needed to file a successive.
You can't file a successive lien to cure an irregularity?
You can file a successive.
And isn't that what happened here?
Right, but in those circumstances, the original lien is discharged, let lapse, etc. In this circumstance, when approached by our client and informed that it wasn't an amendment, it was a successive lien, there's a double liability here. Our client was forced to bond both of those liens, and they still exist and they're still being maintained.
But who caused that issue? Was it your adversary that caused the issue with whether it was an amended lien or a second lien, or was that the county clerk?
It was our adversary. The way that the lien was filed, it was filed as a second lien. That's the end of that question. And so since it was filed as a second lien, and since they knew that they filed a second lien, and since they refused to discharge that lien, that's why we have this claim.
But if the second lien was filed to cure irregularities, why would they release that lien? Then they have no lien.
Well, then they should release the first lien, because it's a fact that both of the liens were found to be valid on their face by Judge Tisch's decision. But Judge Tisch also made a distinction between being valid on their face and ultimately being found valid.
So that is the whole point, though. If you're suing for tortious interference, right? What is tortious about taking a position that you have a lien and then you have an amended lien, and if the clerk thinks it's not my problem, but I'm not gonna give up any rights, isn't that your own economic self-interest right there?
Well, only one lien is necessary to protect your economic self-interest.
Except if you did something improper, which there was a change, right, of who was the lienor, or there were corrections in the second lien, right? And wasn't it called an amendment? Wasn't it filed as an amendment?
Well, no, because it was filed as a second lien.
By who, though? Who was it? Who took the paper and filed it?
Our adversary?
Nope. Who'd the adversary hand it to?
His client?
The county clerk.
The county clerk, I
Oh,
think.
excuse me, sorry.
So the county clerk took this document, which I thought it was either labeled or within its content said it was amending the first document, as Justice Scarpula mentioned. So it was the county clerk then that looked at this and said, I am filing this as a second lien, and then gave your client a memo to that effect.
But is your position then that, okay, even if that error was made on behalf of the county clerk, or that's how they interpreted it, when you presented your adversary with to maybe release the second or the first lien, one of them, they decided not to, and that was the malicious intent?
We allege that they filed it in the first place improperly so that it is a second lien and not an amendment. They are saying that they filed it as an amendment and there was a mistake. The only mistake can be on their part, not the county clerk. The county clerk sees whether it's an amendment or a...
Again, how is that tortious? If there's if this clerk says this is a second lien and there is a court order saying both liens are in, how could that be a tort?
Because their economic...
Because they don't believe you?
No, because their economic interest was already protected by a validly filed lien.
But it wasn't. They didn't believe it was. That's why they had to amend the lien, and they proceeded along that course, right?
They believed that they needed to amend the lien. Even assuming that was true, then there's no reason why they wouldn't discharge...
How is that showing a collateral purpose? Isn't that all showing that they're just trying to enforce what they believe they're entitled to from the project?
If I may, the Farmingdale case is the instructive case here. Just because the process is valid on its face doesn't mean that it cannot be used in a way that's sufficient on a motion to dismiss to sustain the allegations that there was an abusive process. In Farmingdale, each individual subpoena, all 87 of those subpoenas were valid on their face, but it was the context on which they were used.
Because there's 87 subpoenas. This is someone who has a statutory right to file a lien, right? And you may disagree about the number, but they file the lien, and then they believe that there's a mistake in that lien, and they have a statutory right. And in fact, if there was a mistake in that lien, their claim would be dismissed. So they file an amendment, what they believe is an amendment. The county clerk sees it differently, and your argument is that's an abuse of process?
That's what we allege.
Okay.
And just
Finish up, counsel.
thank you.
No, finish up, finish up.
Just the last point is that just because that it was valid on its face, there's a distinction of it being ultimately valid. It's the same thing in what the Farmingdale case stood for. It's two things: that process, even though it's valid on its face, can ultimately be an abusive process, and two, context matters. How it was used, there was a request by the Teachers Association in Farmingdale that the subpoenas be staggered for practical purposes because there's no reason for 87 subpoenas to be for the same date and time. And there's the same kind of context here. We ask repeatedly and inform our adversary repeatedly that this lien was not filed as an amendment, it was filed as a second lien, that they should discharge one or the other. We have no issue with which one it is, and it's been quite some time that they maintain both of these liens on the project.
Thank you. Counsel?
So what is your argument? Why not discharge one or the other of the liens?
Your Honor, there was an issue with the actual filings. The second lien was filed as an amendment. It says on the piece of paper, amended lien. Now, going to your point that you stated earlier, this is something that the clerk did, perhaps as a clerical error, but in the special proceeding before Judge Tisch, we did try to convince the judge that we have no intention of causing any harm here. The second lien is filed strictly as an amendment. And we offered to discharge that lien, that first lien. We wanted to keep the second lien because it was the proper amendment, which we believe was the case. And yet Judge Tisch said that having the first and second lien on the record or in the record is proper under the lien law. So I hope that answers your point. Now, I wanted to briefly state that going to my adversary's point, he effectively stated that what my clients did was proper. There was no malicious intent because he said that the appellant filed the first lien to protect its economic interest, filed the second lien, quote unquote, as to also protect its economic interest. But his issue is just that there's a procedural defect. This is what it comes down to. His argument is that we filed the lien incorrectly.
No, I think his argument is that you filed the second lien unnecessarily, and the error was made by the clerk, not by you.
Well, in the earlier papers, actually, it's in the record, respondents claim that the first lien is defective and is also defective. Only in the most recent complaint filed in the underlying case does he make clear that the second lien is really at the heart of the issue here, that the second lien was filed improperly, and that's the basis for their abuse of process claim and their tortious interference claim.
Thank you, counsel.
Thank you.
Thank you both. Kramer versus Bailey. You may proceed, counsel.
Good afternoon, Your Honors. Emil Samuels with the law firm of Kellner and Kellner for the plaintiff appellant. Your Honors, the party that was let out of this matter by the court below was just as responsible for the defective condition and the failure to warn.
What's the defective condition here?
The defective condition here is a revolving door that is set on a ledge which overhangs by 6 inches the sidewalk below.
Oh, would you agree that, would it be fair to characterize it as a structural condition?
It is a defective
No,
condition.
I'm asking you structural. Are we talking about the structure of the steps, the doors, the sidewalk, the configuration, that kind of thing?
Your Honor, with regard to the tenant, the bar, we're talking about a failure to warn of a known defective condition on its premises.
Hold on a second. There's a lease, an operative lease here, and then there's a definition within that lease that says, that defines demise premises. And then there's also an attachment to that where there are certain parts of the property that is hatched out that corresponds to what the demise premises are in terms of the tenant. The steps that you're talking about, is that part of that or not?
The enclosure of the revolving door is half within the tenancy and half within the structure that belongs to the landlord, according to that diagram. When that door is in an open position, as Ms. Kramer was in, she had 1 foot in the demised premises and 1 foot stepping into a air, which was a 6-inch drop between the platform
So
and the
structural. So the claim essentially is that there's a structural defect, a violation of the building code, et cetera. And why is the tenant under the lease responsible for a structural condition? Because there's no claim here that the tenant made any changes. You would agree with that?
The tenant did not make any changes.
So then what's the liability based on the lease, which says that the landlord's responsible for structural changes?
I'm not talking about the lease. There is a common law duty for a tenant to warn of
So it's a
no-
duty to warn. So the only claim you have against the tenant is duty to warn. Is that a fair statement?
Yes, Your Honor.
Okay, so did your client observe when the warning signs?
Judge, the warning signs are down
Or just
by-
yes or no? Did she observe them?
She couldn't observe them.
She didn't observe them.
She was unable to observe them because they were so low between the dim lighting and the manner in which they were placed at your
Is
ankle.
that what she testified to?
She didn't see them, Your Honor, is what she testified.
Let's talk about, right, what she said is, I didn't see them, right? She didn't say anything about, I couldn't see them, I didn't this, she said, I didn't see them.
Your Honor, a warning at your ankle when you're looking straight ahead through a revolving door with people coming at you conceivably with your hands on a push bar looking straight through a glass door, you can't see a warning at your ankle. And if it's at your ankle, it's not really a warning at all when you're looking straight ahead. This is a bar that serves alcohol. While Ms. Kramer didn't consume any, you have to appreciate that the tenant, who's there for 6 years, is aware of this condition. And warning at your ankle when you're walking straight ahead through a revolving door is not an adequate
But
warning.
aren't you, in effect, arguing that there was the duty to warn, essentially, there was an assumption of a duty, right? In this case, by putting the stickers on, there's an assumption of a duty to warn?
Yes, Your Honor, and by replacing them.
And in assumption cases, don't you need more than that? Don't you need some detrimental reliance, in this case, where the plaintiff admits not to seeing the warning signs? So there can't be a duty under the circumstances.
Your Honor, this is an issue of fact that a jury should decide whether the bar improperly warned or failed to properly warn. Your Honor, their duty arises from occupancy under the lease. It arises from their control, which is shown by the post-remedial repairs, and it arises from their maintenance of the premises. It's a jury question. There is a duty. And Your Honor, if you warn of a defect and you put the warning where you can't really see it, if you look at the photographs, you'll see that.
So you don't believe that under the law, there's a requirement that your client should have or would have been aware of the warning signs, and then maybe you make the argument that they weren't placed prominently, et cetera. If she never saw the sign, she never saw the sign.
And she was unaware of the defective condition, and their attempt to warn was unreasonable and ineffective. It should have been where someone could reasonably see it, Your Honor.
What I would just ask you, since you're over the light, but just think about it for your reply, is so the crux of your case that the lessee had a duty to warn of a condition that was outside of the leasehold?
It was within the leasehold, Your Honor, because the revolving doors come in the leasehold and out of the leasehold. The leasehold is half of the enclosure of the revolving door.
Which brings me back to the point that I started out with in terms of what, in fact, is the demise premises that the tenant is responsible for. And that is not, however you place it, that's not what it is.
But Your Honor, if you rent a facility, if you rent a bar, and you know there's a defective condition with the only way in and out of your premises, you know there's a defective condition because you've leased this place for 6 years and you've replaced the warning stickers, You, as the tenant, are aware of a defective condition. You know that the people coming in and out of your premises could fall. They have noticed that somebody may have fallen in the past. You have an obligation to warn the people coming in and out of your premises, to reasonably warn them and properly warn them and put the warning where it can be seen so that people won't fall.
Even if it's not your demise premises. That's what you're saying. If the lease shows that where the incident occurred is not in the demise premises, you're saying in any event you have a duty to warn?
I believe, Your Honor, that under the law, a tenant has a duty to warn of a dangerous condition on its premises.
No, I'm saying if this isn't in its demise premises, if I know about something that's happening on the second floor, but I don't rent the second floor, you're saying I have a duty to warn on the second floor?
No, Your Honor, I'm not saying that. And the case is cited by the respondent.
That is what I am saying to you. If we find that this area is not in the demise premises, that ends it, right?
With regard to the tenant and the duty to warn,
and you still have the owner in, right? It's not that you don't have recourse here. The owner's the person assuming has the property, right?
Yes, Your Honor, but the issue of recourse is
Counsel, let's
Thank you,
do it
Your
on
Honor.
reply.
Thank you, Your Honor.
Thank you. I appreciate it. Okay, Counsel, you may proceed.
Good afternoon. May it please the court. Kyle Silverstein of Cascone and Clubfell on behalf of the defendant appellants RCQ, the owners of the premises. Just to piggyback off of plaintiff's argument, the position is that there was a duty to warn of this condition.
Do you think that, is there any evidence in the record that the tenant put those warning signs on?
So there's evidence in the record to dispute whether or not he did or did not. And the equivocal answer
What evidence are you talking about?
that he placed the stickers. There was a question saying, since 2010, when you assumed the lease of the premises, did you place the stickers? Did you do anything with the stickers? And he said, I don't know, I might have, I don't know, I don't recall.
And what did your client testify about the stickers?
They also said it's an equivocal response, saying, I don't recall. So
let's assume it's a motion for summary judgment, inferences in favor of the plaintiff, correct? That's a fair statement. So how does the fact that the plaintiff did not see the stickers, how does that play out in the analysis on a duty to warn case?
So I think specific to this case, as there is a question of what the demise premises would be, and I think the touchstone of negligence in premises cases also for a court to determine.
Well, aren't we supposed to look at the lease to see what the demise premises are?
Sure, if you're
Okay,
looking.
if we look at the lease, does the lease show that the area where the drop is part of the demise premises?
It might not, but the question
Might
is.
not, or it does not.
It does not. The problem is, though, I think in a specific instance like this, where the door is a revolving door and it's the entrance and the exit to the bar, one of them, if not the only one that was working that time, is whether or not there was a duty to warn because it was the entrance and the exit to the bar.
Even if it's not the party's demise premises, you're saying they have a duty to warn?
So I think in negligence, technically, you would have to assume it's not always clear cut. Courts are supposed to determine on a variety of factors whether or not this is a reasonable or foreseeable issue. And in that response,
You're saying that I should take on liability for something that I don't rent, that I don't get any money for, that is not my property.
so in your response to plaintiff's counsel, you said I should be responsible for the second floor. That's not necessarily the same scenario here, whereas it's the entrance and the exit to the bar. So you're taking on some sort of obligation because that's how your customers are coming in. So whether or not you technically own contractually a duty that way, we're arguing there's a duty, a common law duty.
But based on what case?
It doesn't necessarily have to be based on a case so much as the court can determine, viewing a variety of factors, whether or not this is a reasonable, if this duty should be imputed to the tenant. And the case that cites that would be a court of appeals case that a plaintiff, that the tenant said that, negligence isn't clear cut. It's the gun case, the Beretta case.
The plaintiff on the duty to warn, isn't the plaintiff's theory in the complaint that there was an assumption of a duty? Am I correct about that, or am I wrong?
I can't speak to the plaintiff's complaint of whether or not there was an assumption of duty. The
Because
position.
how else does the duty to warn arise if it's not based on an assumption because the tenant put a sticker on property that may or may not be part of its demise premises? How else would it arise unless the duty was assumed by placing the sticker, correct?
Yes.
So the fact that the plaintiff did not see the stickers, how does that affect the analysis of an assumption of a duty?
Well, I think because the owner of the bar, in this case, mentioned that there were these stickers, and the post-remedial measure that he controlled the doors by saying, I placed the stickers there, or I may have placed the stickers there, issues some sort of duty not based on ownership, but based on control and occupancy. And that is the crux that was in front of the court, was whether or not, it's not a question of if there's notice at this point. The question before the court, or before this court, is that the motion court found that there was no duty at all, and it seemed to only implicate that based on ownership, not necessarily premises, occupancy, or control. So for all those reasons, we're requesting that the motion court's order be reversed. Thank you.
Good afternoon. May it please the court. Ira Goldstein with Morris Duffy, Alonzo, Faley, and Pickoff for the tenant, the Bailey Restaurant Group. Your honors are all on the right track.
Well, let me just ask this question before you jump into something else. Why isn't that a question of fact? No one knows where this sticker, who placed the sticker. Why isn't that enough for a question of fact?
While some of the testimony was inconclusive about the origin of the sticker, it is crystal clear that the stickers pre-existed the tenancy. We submitted photos taken before this, and our client, the owner, Mr. O'Brien, testified to that fact, that he believed these were there before. He wasn't sure if he replaced
He may have
them.
replaced them, but the stickers were there before
They were
your
there,
client
so
ever
if
came.
any, at worst, he replaced them, and that,
So is your argument, you can't possibly assume a duty when the stickers are already there? What
Well,
about the fact that the plaintiff didn't see the stickers?
well, correct. That first part, we didn't replace them. Even if we did, I mean, they were there already, so that's not assuming a duty. But the most importantly, as Your Honor pointed out, there was no detrimental reliance. That's what you need to assume a duty.
Is plaintiff's theory based on an assumption of a duty in the complaint?
I'm sorry?
Is plaintiff's theory with respect to the duty to warn, is it based on an assumption of a duty, or is it just based that there's a common law duty to warn, blah, blah, blah?
Well, it's mostly because it's right outside the bar, that we somehow have control over that when it doesn't make a difference. As it was indicated, it was on the second floor, a foot away from the bar, a mile away.
Does the leaf show that that area where she fell is part of your demise premises or not?
Absolutely. It specifically is that.
I think the landlord sort of kind of admitted that that's not your demise premises.
Well, this was never in dispute, apparently, until now. The oral argument transcript to the lower court, that's not even an issue. Everyone conceded. That's not. The crosshash marks in the lease show that area was specifically excluded.
You have no landowner duty under the lease.
Correct. We have
So the only
no
thing it
structural
could be
repair
was the
obligation.
duty to warn, right?
Correct, correct. And alternatively, our expert found it's not even an actionable condition. It's in compliance with the 1968 building code, which was the applicable code.
Yeah, but they have an expert that says something else.
Well, their expert's opinion should be stricken. It's based on the wrong building code, misinterpretation of the term floor area, while our expert is spot on with everything
Given
he
the
said.
proximity of the alleged defect to the door, at least a portion of which is in the leasehold, where else could a warning be posted other than within the leasehold?
Right, I mean, it's right outside. I mean, that's the most obvious area. And again, it was pre-existing. So whether we place them or clean them up or what, it's irrelevant. And
Well,
again,
I think if I understood your friends correctly, that this is like the sole means of ingress and egress to your establishment. And so the defect appears right outside of the leasehold proper. There's no other place in which it seems a warning could be placed about it other than on the door, and the door is admittedly at least partially in the leasehold.
well, we have no control over that. They took control of that area. But this door is also another entrance to the hotel. So this isn't just our exclusive entrance to the bar. So don't let them fool you. It's in the record.
Well, that's why
This is
the
another
owner wants more company. Anything else, counsel?
That's it. We rest on our brief. Thank you.
Your Honor, this is the entrance to the bar from the street. This is not the entrance to the hotel. And Your Honor, There is a common law duty to warn invitees of a known hazard that they may foreseeably fail to acknowledge.
So known hazard, so in other, was there notice with respect to this alleged hazard before that you've been able to establish, which maybe creates a duty to warn?
The bar owner said that he believed he may have been told prior to the plaintiff's incident that someone had fallen. That's notice. The posting of signs is notice of a defective.
But so now counsel says that the warning sign was there before the tenant got in, right?
And the tenant then replaced them and didn't put them at a reasonable level where a reasonably prudent person could see them.
But you can't assume a duty if you just replace something that somebody else. You're saying I did something affirmatively.
Your Honor, what I'm saying is that the defective condition is this far off of the demised premises within the enclosure of a revolving door where you can't ascertain or see or appreciate the precipitous drop of 6 inches.
Right, and the owner, that's the owner's property, right? The owner has an obligation to maintain that property. The owner has an obligation to make sure that it's safe, right?
A tenant has
The question is whether the tenant, whose this property isn't, also has a duty.
Your Honor, if I may just get one last point in, a tenant who's in possession of that property for 6 years, who knows of that defective condition, has an obligation because of occupancy, because of control, because of maintenance of that demised premises, to warn of a known danger. And they failed to do it in this case.
If I may, sir.
Yes, Your Honor.
What is the strongest precedent in your view that would support imposing a duty here?
Your Honor, I believe the duty here is both an assumption of duty by the replacement of the signs and not putting them at a reasonable level, and I also think there's a common law duty to warn because they're a tenant in possession.
I'm saying, what case do you find that in? A tenant whose property it isn't, because they see it, or they see it's there, they have a duty to warn. That's what I'm trying to figure
Judge,
out.
I would rest on the remainder of my brief for that position.
Fair enough. We'll look into it. I appreciate it.
Thank you.
Thank you all. People versus Hoover. You may proceed.
Good afternoon. Karen Brill with the Office of the Appellate Defender on behalf of Patrick Hoover. I would like to focus on the excessive sentence point because Mr. Hoover would ask that this court only reach any of the remaining legal claims if you are not willing to reduce his sentence to at most the term that respondent consents to, which is 4 to 8 years. Turning there, respondent agrees that Mr. Hoover should receive the minimum on each count, which is 2 to 4 years, but maintains that one count should be left to run consecutively. We would ask that this court instead impose concurrent counts across the board. These cases are all explained by Mr. Hoover's destabilizing deportation to the US, where he was separated from his 2 young children, from his partner, and from a stable business that he had started, which was a trauma that led to the spiraling addictions that the court below recognized were at the heart of these cases. For more than a decade in Canada, Mr. Hoover lived successfully as a stable family man and as someone who was growing his own business. What changed is that he was deported to a country he had not stepped foot in since he was 2 years old, and he was separated from every meaningful source of material and emotional support he had in this world. As he began to lose hope, a problem that he'd had with pills since having a car accident in Canada spiraled into these severe addictions to heroin and crack cocaine. That context, and particularly that success that Mr. Hoover has been capable of when he is appropriately supported in managing his drug dependency, is crucial context to assessing the appropriate sentence. And in fact, it's the same context that the court relied on in accepting a diversion plea, which contemplated that Mr. Hoover's crimes didn't inherently require any incarceration at all. Now, obviously, he did not complete treatment, and so he's...
Wait a second, let me go back. When he took his deal, it was 2 to 4 years consecutive if he didn't follow through, right?
The contract had a term for...
And the max was 3.5 to 7. That's the deal that he cut. And then he came back, he didn't go, he was unable to finish it, and then he got rearrested. So he was technically exposed to 3.5 to 7, 3.5 to 7, and that's what he got, right?
That's right.
And so the people are saying, we'll go back to the original deal as if he hadn't have gotten rearrested and do 2 to 4 and 2 to 4. And you're saying that's not what you want?
I think this is a unique case where an even lower sentence is warranted. The terms of the contract actually contemplated a lower sentence because they said that.
No, I just looked at it. It said if you don't complete this program, it's 2 to 4 consecutive to 2 to 4. That's what it was contemplated. And that was only if he didn't get rearrested. And he did get rearrested.
So in paragraph 6 of the contract, it says that if someone is rearrested, what the court should do is evaluate all of the facts and circumstances and impose an appropriate sentence up to that maximum. I think here what we have to look at is why he...
I understand that, but the judge did say, in fact, 3.5 to 7 if you get rearrested. So I understand that you're trying to say that it's excessive and in our interest of justice powers that we should just run it concurrent. What's the harm? Right? Is that your position?
That's what we're asking for. But I think it also is contemplated as a possibility under the plea agreement. I'm not saying he was entitled to that, but I also think what 4 to 8 assumed in the contract is that he'd have a fair chance at treatment. And so I'd ask this court to look at what happened when he went to the program, which is that unexpectedly, by virtue of where the program was situated, he quite literally passed his former drug dealer. And
Did he make it to the program? I thought he jumped out of the car on the way to the program.
He did not jump out of the car. He left during intake, and that was because on the way into the program, he literally passed his former drug dealer. And I'd ask this court to look at this as a matter of chemical dependence. There's scientific literature that I cited in my brief that when people who are in this kind of dependency see people who are accused of their former drug use, they feel physiological symptoms that impel them to use drugs.
Why shouldn't he be held to the bargain? If you're saying the bargain is 2 to 4, 2 to 4 consecutive, why shouldn't he be held to that bargain? Under the circumstances, the fact that he left the program, he was rearrested, all those things, wouldn't that be a more appropriate sentence here?
I think it's certainly more appropriate than the sentence he got, but I don't think the contract mandates that sentence. I think the contract contemplated that the court would consider all the facts and circumstances, which include why he failed treatment.
Did he contact his attorney and say, look, this program's not working with me, I can't go there for all the reasons you say, and maybe they're really good reasons. Did he do any of that?
Well, Mr. Hoover asked for another chance at program once he was put back in court. The court summarily dismissed it after the prosecutor asked to proceed to sentencing.
He was arrested, but he was rearrested by that time.
He was rearrested.
I'm set between the time he left the program and the time of his rearrest. He didn't take any steps, correct?
No, and that was a 3-day period in which he was on the streets actively seeking drugs.
He was rearrested for a different crime 3 days later?
Yes, what happened is that he relapsed and immediately began seeking drugs and committed a similar offense in order to buy more drugs. Again, it's unfortunate, but what diversion programs recognize is that to interrupt that cycle, you need meaningful treatment. And the last thing I would just add, Your Honors, is that his MDC agreement said that he needed a year of inpatient treatment where he would have had no access to any kinds of temptations and triggers. Unfortunately, he didn't get that because he was triggered before he even got through intake. And so given that, we'd ask that this court impose a sentence at or near the total minimum, which was 2 to 4.
Thank you, counsel.
Good afternoon, Your Honors, and may it please the court. Emily Galtz on behalf of the people. The people do not oppose reducing defendant's sentence in the interest of justice to an aggregate term of no less than 4 to 8 years in the interest of justice.
Why shouldn't we do it concurrently, based for the reasons your adversary is expressing?
So the 4 to 8, so the 2 to 4 consecutive, so 4 to 8, that was the exact sentence he were to receive if he just failed the program, straight failure. Defendant here not only absconded from the program 2 hours after arriving, but as Your Honors pointed out, he was immediately arrested. His history relates to is a lot of theft related. He was he was sentenced as a second felony offender. So he's not deserving of to run the sentences concurrently. This was a really great deal. He had the opportunity to avoid no jail time, no conviction whatsoever.
But recognizing addiction and how the laws and the evidence-based practices have changed over the years, and we understand what addiction does, why isn't it reasonable to run that time concurrent?
Well, I think given the circumstances here, Your Honor, I understand your point, but the circumstances here was he was told he could face up to 7 to 14 years, the 3.5 to 7. And the problem was the plea judge said there are no promises if you violate or if you fail the program and get rearrested. There are no promises, but you can face up to this. And then at sentencing, we said we're relying on the promise. That wasn't actually promised to him, although it was a lawful sentence that he received. That wasn't what he was promised. So given the circumstances here and the record below, the circumstances here and the record below, he's not deserving of any better of a deal than that, especially, again, after failing the program 2 hours after entering and immediately getting rearrested. So if Your Honors have any other questions, we don't oppose reducing the sentence to an aggregate term of no less than 4 to 8 years.
Thank you, counsel.
I think if I could just zoom out briefly, I think it's rare that we have a record that is this clear about who someone is and what they're capable of when they are supported in managing a drug dependency and the mistakes that they make when they are not supported. Mr. Hoover achieved incredible things in his life in Canada, and I think what the diversion program was aimed at was recognizing that to get back to that life, he needed a year of intensive treatment where he was completely separated from temptations and triggers. Now, he made a mistake in leaving treatment and in being rearrested, and that's why he's not entitled to dismissal. But that mistake, viewed in the full context of the seriousness of these addictions, which again were serious enough that a court credited he needed a year of inpatient treatment, I say that a near minimum sentence is truly appropriate for Mr. Hoover, given everything that he has achieved and everything that he has gone through. Thank you.
Thank you, counsel. Thank you both. Titan Industrial versus Navigators Insurance.
Good afternoon. My name is Ann Odelson, and I represent Titan and Scottsdale Insurance Company. This is a pretty straightforward case. One of Castle's employees was injured. Prior to the accident, Titan and Castle entered into a contract which contained insurance procurement language in which Castle agreed to defend, indemnify, and procure primary and non-control.
I think we're familiar with the facts here, right? So the question is what precisely is endorsement 5 in this case?
So it's an exclusion.
Well, why do you say it's an exclusion?
Because it takes away coverage. There's an additional.
Well, does it say it's an exclusion?
It clearly says it's an exclusion, a designated person and entity's exclusion. And yes, Titan is named in that exclusion, but there's also additional insured endorsement in the navigator's policy. But for this exclusion that says Titan is not entitled to coverage, the policy would provide coverage. And in that situation, Court of Appeals has held where the policy would provide coverage, but for an exclusion, 3420D applies.
And the disclaimer here is based on endorsement 5, correct? It's not based on some
Bunch of
others,
different
like section 2, for example.
Well, the disclaimer was late, and the disclaimer also tried to, that was the main purpose. It was exclusion, that Titan was excluded from coverage, and that was sent years after the tender. But there was also labor law exclusions too in the policy the navigators tried to rely upon. So navigators
those got mooted out essentially after summary judgment, right? On the underlying case.
Court really didn't. The court focused on the exclusion in the policy and basically said that it wasn't an exclusion. But like I said, things would be different. Can't waive into coverage when it didn't exist in the first instance. If you didn't have the additional insured endorsement, there's a certificate of insurance. Granted, it's not evidence of coverage, but that was issued referring to the navigator's policy by this broker, which I'm sure you're going to hear about, navigator's policy, and it refers to Titan as an additional insured. So there is, like I said, they charged a premium, got the additional insured endorsement contained in the policy, but they threw on this exclusion. In those situations, if that exclusion didn't exist, I wouldn't be here before you because they get additional insured coverage on a primary non-contributory basis.
Thank you.
May it please the court, Guyan Knight on behalf of Navigators. The Zappone case from the Court of Appeals shows...
Before we go to case law, just let's go to the policy. What does endorsement 5 say? What is endorsement 5?
Endorsement 5 is not an exclusion. It is a...
I know you argue that. You say it's an amendment to Section 2, but it's entitled exclusion. So why should I not look at that language and say it's an exclusion?
For two reasons that the Zappone case lays out. The Zappone case says if coverage does not exist in the first instance, then the provision that you're talking about is not an exclusion. Here, endorsement 5 says the persons below are not an insured. The second thing the Zappone case says to look at is, was there premium collected to cover this risk? And on page 877 of the record, we have an email between the brokers saying, we are not going to put Titan in the application for insurance. That had the effect of reducing the premium, exactly what Zappone says doesn't qualify as an exclusion. Another problem with the argument of Titan and Scottsdale is they're asking the court to read the policy serially. The endorsement 5 and the rest of the definition of who is an insured have to be read together at the same time. And when you read them together, the only way to harmonize all of the provisions of the policy is to give effect to what endorsement 5 says, which is that Titan.
In other words, we should ignore language which says that certain entities are, quote, excluded from coverage, that's not an exclusion, correct? I mean, that's your argument.
You certainly should not ignore any of the language in the policy.
But wouldn't we be ignoring that language if we accepted that position? Putting aside the issue about the premium, but isn't that a problem?
You would not, Your Honor, because before you even get to that, it says very clearly, not an insured. But also, let's say that it is an exclusion, although for all the reasons we've said, it is not. There is still a timely and valid disclaimer under 3420D. The disclaimer came 24 days after the tender was received. And the disclaimer said, I believe that this totally cuts off coverage.
So that's the email from your claim specialist, Ms. Glynn?
Correct, on page 404 of the record. And
What is demanded under 3420 for there to be a valid written notice of a disclaimer?
It has to give particularity, specificity about the reason for the disclaimer. Here, that's not an issue because endorsement 5 was actually attached to the disclaimer. The only way that they're saying...
That's assuming that that email was the disclaimer, right? I mean, that's not, I believe that that's not necessarily an equivocal statement that we are denying coverage.
So I've been listening to all the counsel argue today. I've sort of lost count of how many people have stood up here at the podium and said, I believe it's our position. What they're trying to do is use language of politeness and trying to use that as a word game to hoist us on our own petard. There was no debate. There was nothing in the record showing that Titan was ever unclear as to Navigator's coverage position. We gave them the exact provisions we were relying on. We gave it 24 days afterwards, which is timely. That's what's required.
Wasn't part of that email, though, words to the effect, look this over, let me know what you think, or think about this? It seems to me that the whole purpose for demanding, no pun intended, an unequivocal and clear and unambiguous disclaimer is because of the high legal stakes that are, that flow from that the reasonable period of time then is going to be measured from that date.
Every disclaimer of coverage contains similar language because insurers are always saying, if you disagree, let us know. Give us more information. Tell us you disagree. The fact that the email on page 404 does not includes that language of tell me if you disagree does not mean it's not a disclaimer. It just means it's a politely worded disclaimer. And again, to return to the actual language of the endorsement, that's
What language in the email are you saying you unequivocally disclaim coverage?
the policy contains the attached two endorsements, and I'm reading from page 404, that I believe would preclude coverage for this matter and remove Titan for coverage completely under our
I
policy.
believe you're saying that is your unequivocal, we're not going to pay?
Yes, Your Honor. There was also conversation between these two people on the very
Did
day.
you actually send out a written disclaimer of coverage?
There was a second tender after Titan sued Castle for not obtaining the insurance that Titan is saying they did obtain.
So why did you send that out if it's your position that that email did it?
There was a second tender. We can't just not respond to a second tender. The reason there was a second tender is because the first tender was disclaimed.
But the way that second disclaimer went out, it's significantly different from that first email. In fact, the second one says right on it, disclaimer.
Yes, the second disclaimer is a formal letter. But Justice Scarpulla's own jinx-proof case that went up to the Court of Appeals says even if there is confusing, contradictory language in a disclaimer, even if the disclaimer is called a reservation of rights, even if the disclaimer says, I'm waiting for more information, if it has the effect of a disclaimer, it still qualifies. There is nothing in that email suggesting that more information was needed. And if you look at the language of endorsement 5, it says they are not an insured. Thank you.
Thank you, counsel. You have a minute, counsel.
Just briefly addressing your arguments that email did not comply with 3420D, and they knew it didn't comply with 3420D because then they sent out, like you noted, a formal disclaimer. So it's a harsh statute. You have to do certain things at an insurance company, and as you all know, you got to do it in a timely manner. In jinx-proof, court found even though that it contained reservation of rights language, it still made the message across, got it in a timely manner.
Why didn't the email of the specialist?
It says it may apply. It's not even.
It's not unequivocal, is your point.
It's not an unequivocal disclaimer. In terms of Zappone, where a policy would provide coverage but for an exclusion, 3420D applies. They charged a premium for an additional insured endorsement that they smacked on that policy with primary non-contributory language. But for that exclusion, which is clearly labeled an exclusion, they're entitled to additional insured status.
Thank you, counsel.
Thank you.
People versus Esquilin.
Good afternoon, Your Honors. Taylor Napolitano with the Office of the Appellate Defender on behalf of Rafael Esquilin. Mr. Esquilin's case comes to this court after a long procedural history that's important to the context of his claims. At trial, he was acquitted of murder and conspiracy, but convicted of manslaughter and related charges. At sentencing, counsel successfully challenged his adjudication as a persistent violent felony offender, and he was sentenced to a determinate term of 25 years. 3 days after he filed his notice of appeal, the state filed a notice of appeal attacking his sentencing, essentially seeking that he be resentenced as a persistent violent felony offender with a life term tacked on the end. On appeal,
Our 2019 ruling on in this particular matter affect your case? Let's just move forward.
Sure, Your Honor. On appeal, this case was remanded for resentencing At that resentencing, OAD represented him and looked into his predicates again, the 1993 and 1999 convictions. Following our investigation, we realized that there were constitutional infirmities with the 1993 conviction that counsel in
Let's address
1999
the
failed to
93
challenge.
conviction. Was he required to challenge it in the 1999 plea proceedings?
Your Honor, he raised these challenges via 44020 in the 1999 proceedings, and that motion was raised, can be raised at any time, and under Juergens is the proper vehicle for challenging the use of that predicate and at a subsequent sentencing. So when counsel OAD realized that there was this infirmity with
Well, I'm sorry, so your position is that there's no waiver and it can be.
Yes, Your Honor. Position is there's no waiver here and that we don't even need to get to the ineffectiveness or anything like that based on Juergens, which is cited in our brief. With that, I'll just turn straight to the predicate issue then. Mr. Esquilin was wrongly adjudicated a persistent violent felony offender here on the basis of the 1993 predicate, which was unconstitutionally obtained. In 1983, at age 19, Mr. Esquilin was indicted of second-degree robbery, and then at arraignment, he pleaded guilty to the uncharged lesser of attempted second-degree robbery. His plea did not meet federal constitutional standards because the court failed to inform him of all of the elements of that charge. Attempted second-degree robbery requires an attempt to cause physical injury, which was never uttered at the plea. The physical injury element here is very consequential. It's the sole element that distinguishes attempted second-degree robbery, which is a violent felony with an enhanced sentence, from third-degree robbery, which is nonviolent with no enhanced sentence. The court also never ascertained on the record whether counsel reviewed those elements with Mr. Esquilin, who, remember, was pleading at arraignment here and is only 19 years old. And it bears noting that today, we are moving away from taking pleas at arraignment because of the new discovery laws and the idea that defendants should have a full examination of the evidence.
To felonies at arraignments, but wasn't there some sort of allocution about him kneeing someone and ripping the chain off the neck, and fighting, I think, was the other part of it?
Your Honors, an admission of force is not an admission to the physical injury element, as there can be a use of force without an injury. And a plea is supposed to be equivalent to a jury finding. And while a jury can infer from force that there was physical injury, they certainly did not have to. And under federal law, the court needed to ask about that element or ascertain on the record that the counsel had spoken to him before the plea about this. And that comes from Henderson v. Morgan, which is cited throughout our briefing, and that when the defendant pleads to an offense but is not apprised of the elements by the court or counsel, the plea is unknowing and involuntary. And in Henderson, the defendant was charged with first-degree murder, and the indictment read that he willingly killed the decedent, and then he pled to a second-degree murder of intentional murder, but the court did not state that element at the plea or ask whether he had talked to his lawyers about it. The same is true here. It maps onto ours exactly. And anything the respondent cites to the contrary are cases about the sufficiency of the evidence at trial, where the reviewing standard is to view the evidence in the light most favorable to the people, which is neither the inquiry here nor the appropriate standard. We are looking at if the plea is knowing, involuntary, and intelligent, with no finger on the scale in favor of the people. In addition, the court failed to inform the 19-year-old Mr. Esquilin by pleading guilty he was waiving his right to silence, that he was pleading to a violent felony, or that by pleading to a violent felony, that would enhance his sentence there and in the future. The cases respondent cites to the contrary only have one missing Boykin right, or defense counsel stated on the record that they had gone through the rights with their defendant, and the defendant had been represented for a long time by counsel. Here, Mr. Esquilin was 19 years old, pleaded at arraignment, and the court made no inquiry of him about this element. With that, I'll just rest on my briefs and come up on rebuttal.
No.
Thank you, counsel.
May it please the court, Alex King for the people. To begin with, defendant's belated attack on his 30-year-old conviction is both waived and precluded. Defendant, of course, could have challenged his 93 conviction.
Well, why don't you talk about the plea? Because I think that might be a bigger issue.
So
the elements that weren't necessarily, he wasn't questioning about.
Yes, Your Honor. So he entered a valid plea in 1993. The surrounding circumstances demonstrate that because he was represented by counsel who participated actively, secured a very favorable agreement for him, and also provided advice to him off the record immediately before the plea was entered.
Was the court required to go through every element of the charge with, in regards to the plea?
Now, certainly it was not, Your Honor. The court can presume, this court can presume under long-established precedent, including this court's decision in Montford in 1987, that counsel fully explained the nature of the charges to his client. Further on the point of the elements, defendant need not allocute to every element of the offense to enter a valid plea. But still, his admissions during the allocution that he fought with and kneed his victim and ripped a chain from his neck established all of the elements of attempted robbery in the second degree. In sum, defendant's attack on his 30-year-old conviction is waived, it's precluded, and it's also meritless, and this court should not disturb his adjudication as a persistent violent felony offender. Thank you.
Thank you, counsel. You may proceed, counsel.
On rebuttal, I'd just like to briefly address that the respondent said that we can assume that counsel asked him about this. He wasn't asked about that on the record in 1993 about the representation of counsel. So there's nothing on the record about whether or not he and counsel talked about it. And again, he was pleading at arraignment. And then just briefly, I'd like to address that if this court doesn't agree about the predicate challenge, there's still an excessive sentence claim here. We're asking for 20 to life, which is the lowest possible sentence here, which would mean that Mr. Esquilin would not get out of 20 years, but would have to see the parole board. And he put forward evidence at the resentencing that he had ample support, family and friends, who would assist him upon reentry. He also has used his time well while he's incarcerated, seeking various professional certifications that will also help him upon reentry. And it would better reflect that the jury acquitted him of the second-degree murder and the conspiracy here. And it would also be more commensurate with what the other co-defendants got here. Mr. Herrera, who's the person who committed the killing, got a 20-year flat sentence, and Mr. Beniquez, who was convicted of the second-degree murder, unlike my client, got a 20 to life. Thank you, Your Honors.
Thank you both. Goodell.
Good afternoon, Your Honor. Seth Weinberg for the defendants. In reviewing plaintiff's brief, it seems to me the parties now agree this is an assumption of duty case and not purely that hotels have a duty to prevent suicide in all circumstances. So with the court permission.
Let's deal first with assumption. Did your client, through the hotel clerk, assume a duty here?
No.
And why is that?
To assume a duty under the Court of Appeals precedent, you have to put the plaintiff in a worse position than if you had done nothing. And when you look at the facts of this case, the decedent was in the same position as if we had done nothing.
Can we say that as a matter of law? I mean, because we know, for example, when he was looked on, I guess it was a check made around 6:34, the report back was that he's fine, but in fact, the incident report suggests that he wasn't fine. And didn't his condition deteriorate over time, or couldn't a jury find that the condition deteriorated over time, resulting in ultimately him going on to a ledge?
No, Your Honor, for several reasons. And I think the best way to look at it is to compare what the decedent's condition was at that first check-in and when the police ultimately entered the room. At the time of the first check-in, the liquor bottle was empty.
There were a couple liquor bottles, actually.
It might have been one or two, but liquor bottles empty, pill bottles were empty. And based on the family's testimony, he had already been out on the ledge.
And also he had a red face, apparently he was crying, right?
Correct.
But what was the report back to
He said he was fine, and that's what was reported back based on his representations of what he said. And when the police got there, he had already imbibed the alcohol, he had already taken the pills, and he was on the ledge he had previously accessed and was still alive, and the police had the opportunity to speak to him and try to get him off the roof. So the only real question is, if the police had gotten there earlier and forced their way into the room earlier, could they have stopped it? And the short answer to that question is, no one can know.
Well, that goes to causation. So first, let's just finish with duty, assumption of duty.
Well, they're interrelated, Your Honor, because ultimately you can't, how can you tell if the person was in a worse off position if you don't know what the result would have been? So they are interrelated. If we don't know that he could have been saved, then we don't know if he was in a worse position.
But in fact, there is expert testimony, which I imagine you would say is speculative, which suggests that given his progression of the suicidal, the ideation, that actually maybe he could have been saved in the beginning. That's from the doctor. Then you have the police expert who discusses what the police procedures are when they deal with people like this. They can be taken into protective custody. Why is that not, then, if we're going to talk about causation, really an issue for the jury to decide?
So let me deal with the police expert first. The police expert presumes he couldn't have gotten onto the ledge when the police got in eventually. Basically, he sort of assumed that he could have been tackled in the room. There's no reason for that belief, and the protocols were followed. The police officer got there, spoke to him in a calm voice, tried to convince him to come
Right, but an hour had passed, right? About an hour?
Depending on when you count from, Your Honor. But the point is...
Is there any way to know that whether or not he was on that ledge for the entire hour?
No, because there was no way to know anything what was going on in the room.
So he could have been exactly in the same spot if they had called
In fact, one
5
could,
minutes, 10 minutes, 20 minutes, 2 hours later.
one could infer that the
in
15
the
minutes...
Same spot, right?
I'm sorry, Your Honor. One could infer that the 15 minutes or so that the hospital staff were pounding on the door, he was on the ledge and came back in and then immediately went back out on the ledge. And that's why at page...
Well, we know he's in the room at 6:34. We know he's in the room, and according to your client, he's in good condition. Everything is good. And we know that, in fact, that's not accurate because time goes on and his condition is deteriorating based on the text messages received.
Does
by
your
the family.
client
Let me
know?
finish.
I'm
Let me
sorry,
finish.
I'm
Let me
sorry.
finish.
I just want.
Isn't that correct?
No, it's not correct.
Why?
Does your client know that he's not in a good spot?
No, our
He
client...
says, "I'm fine," right?
Our client has
Is
a
your client
representative...
a doctor or a psychiatrist?
It's a front door
clerk,
attendant
right?
and a bellman.
And the client and the person knocks on the door. How you doing? I'm fine.
And let's take it further, and let's take plaintiff's suggestion of what was supposed to be done at that moment. What was to be done at that moment, and this is at page 42 of plaintiff's brief, the doorman was supposed to distract the decedent and keep him at the door long enough so that the front attendant could slip away, call the police, and then keep him at the door long enough so that the police could arrive. If the doorman failed, and all the decedent does is close the door and lock it, we're here where we are. My red light's on. I didn't get the proximate cause.
No worries. I'll give you 2 more minutes. How's that?
So the reality is there's just no way to know, which leads into proximate cause. Just to take a question, I'm sorry.
No, I was going to ask, let's assume that we found there was an issue of fact as to the assumption of a duty. Could you address your proximate cause argument?
I will, but if I can just briefly remind the court below didn't find question of fact on assumption of duty. They found we assumed the duty. So at a minimum, that needs to be dealt with. But let's assume for the sake of discussion, we get past that. It goes back to...
How could we find an assumption of a duty? Plaintiff didn't move for summary judgment, right? I mean, so it's that would be...
Well, what the judge found was we have a duty, and the question of fact is proximate cause. So that's... They are somewhat interrelated, though, as I was trying to get to before. Let's focus on the expert opinions here. I think we can take the hotel expert out because he was trying to argue that all hotels have a duty. That's not the position of this case anymore. With the law enforcement expert, at the end of the day, the police were called, he was alive, and there was an ability to follow protocols. They were not
Well, how do
successful.
you deal with the hour, that hour?
I'm sorry, Your Honor?
Between the hour when the woman didn't call the police herself, but told the front door clerk to call the police, how do you deal with that hour?
So for the hour to work, we have to assume a few things. Option one, decedent was still in the room and could be restrained, because that's why the officer couldn't restrain him and stop him. The officer would have gone over. No evidence to believe that was or was not the case.
Is there any, right, but this is a motion for summary judgment.
Correct.
So there's no more evidence.
Right. So the point is,
There's no one who's going to be able to tell us.
he was alone in the room with the door closed.
Or he could have gone out for 45
And with the
minutes.
window open. So exactly right. So then we get to, he's on the...
Well, let's just back up. If you had called the police as your client said they'd call the police, would you agree that the duty is discharged at that point, irrespective of what happens with the police? I would submit to you that's the end of the case, because you assumed a duty, you said you'd call the cops, you don't call the cops, but in this instance, if you had called the cops, what more could you do? Nothing, correct?
Agreed,
All you
but
could do is call the cops.
that's inherent with assumption of duty, right? I mean, at the end of the day, I could have always done something more. If I have no duty, if my client could have done that on the first phone call.
That's
said,
right.
Ma'am, I'll call the police, and could have, and his plaintiff conceded.
Or the opposite.
As callous as that
opposite.
might have been, and that's the point. With assumed duty, it gets tricky because one.
Well, I think that's maybe the point that I'm thinking about. So I understand you all are focusing on the assumption of duty, but why is there a duty at all at that point?
At which point? Your
At
Honor?
any point.
I don't think there is because we didn't assume one. We never get there. And if I can get back to proximate cause, let's assume for the sake of discussion.
But you just conceded before that the issue is assumption of duty, because that's how the briefs have been addressed. It's not a question of, because I don't think anybody suggests that there is an underlying duty for the hotel to prevent suicide.
What?
The question is whether or not there was assumption of duty, and the more difficult question is whether or not there's causation.
If there's a duty at all, it's assumed.
Well, isn't there an assumption based on that, based on our case law? Isn't there an assumption? You conceded that in the beginning of your argument.
No, I didn't. Your Honor, let me clarify. I was not conceding there was an assumption. I was clarifying. I was conceding. I was trying to eliminate the
That's
idea
the
there's
issue.
no duty.
Yeah, it's
The
not
issue-
an attempt to extend the common law duty.
And why don't you think you assume the duty?
Because you have to put someone in a worse position.
And there's no evidence here. that-
Exactly. I can assume a duty. I'm sorry. I can say something or do something that doesn't assume
So
a duty.
based on your words, in other words, when you report to say that the person is fine, right, is fine 4 minutes after that phone call or 5 minutes, and we know, in fact, that person is not fine, can't the jury make a decision, a reasonable decision that the condition
No.
of that person was deteriorating?
I would submit no, Your Honor.
Okay.
And if I can get to proximate cause, I know the red lights. I'm trying to respect the red light.
No worries. Have you noticed how flexible we've been with red lights?
I understand, but it's going to be a good evening soon, and I'm trying to respect the.
Okay.
Thank you. Just a second. I'm sorry.
I just wanted to ask you about Dr. Fayer's affidavit, which I think Justice Singh mentioned earlier.
So with regard to Dr. Fayer, and really any expert, and this is what I was trying to get to before, and we touched about if the police arrived and he was in the room, I mean, presumably we can assume they would have tackled him and if they had to and whatever. But since we don't know, if he was on the ledge, he could have gotten to the ledge. So let's just say, because that's the only other option, he's either in the room or on the ledge.
Is there any evidence at all what he did for that hour?
At some point, photographs went forth with his feet over the ledge. It's not crystal clear when those happened. The family didn't save the text. And there were calls going back and forth. It wasn't just the first phone call. In fact, the request for 911 wasn't the first phone call on the check. The request for 911 was later.
Right.
So where
It
I'm
was
trying,
just go to check on him.
right, please check on him. We
Well,
say
it was
he's
20
fine.
minutes later, and the reason why the call was made, or the request was made, because based on the text messages, the family was concerned.
Yes.
Fair enough?
Well, so the family was concerned. The staff goes up. The reason it takes 20 minutes to call back is they're pounding on the door for 15 minutes. He comes, answers the door after 15 minutes of pounding, says, I'm fine. They call back, say he's fine. That's reported. He then sends another text message. More text messages go back and forth. The family calls back again, and that's when the dispute arises as to whether we said we would call 911 or not. So the reality is, Justice Singh, the call you're focused on, there was no request for 911. So for your call to work, we would have to say to the decedent, we don't believe you, you're not fine. Either open this door and come out, or we're calling the police and throwing you out. It's not a reasonable standard or option. To get back
No,
to
but what about the second call, when they say, go call the police, and it takes an hour to do it? That is, why haven't they assumed the duty to go right across the street and call the police? Or call the police
yeah.
the minute after the woman calls?
For the same reason I've been trying to say over and over again, which is they didn't put him in a worse position. And we know they didn't put him in a worse position because he was alive and able to be talked off. It didn't succeed, and that's where I was trying to get to with Dr. Fayer. Let's assume for the sake of discussion, since we've talked about there are two choices. It's undisputed, there can only be two choices. He's in the room, at which point presumably he could have been restrained, and this unfortunate event, and it truly is an unfortunate event, does not happen. The other option is he's already on the ledge. And if he's on the ledge, there's no reason to believe one way or the other that exactly what happened wouldn't have happened. He was lying in the fetal position. The officer tried to talk him down. He gets up, starts to walk toward
And how long did it take for the officer to get to the point where he was talking to the decedent? About an hour or so?
Depending on when you measure it from.
Well, whatever, half an hour, 45 minutes, time goes by.
Yes.
And there is testimony that this person was savable in the beginning by the doctor.
Well,
So that's the test, that's the opinion. Maybe it's speculative, maybe it's not, but that's the opinion.
but if it's speculative, that's a major
Well,
problem
that's,
for
but
summary
that's,
judgment.
that's.
And that's why I'm saying it is speculative, because ultimately, we have to think about what the response was. The gentleman turned around and wags, no, no, no.
And, but which is an hour later. And that's where the hang-up is, at least
But
for
that's
me.
the point. There's no way to know.
Fair enough.
There's zero way.
And there's nowhere to know where he was. He could have been on that ledge for the hour, and as soon as the...
And hence why it can never be known if we put him in a worse position, why there can never be.
Or he could have gone out and gone to a bar for 45 minutes and came back. We don't know.
We don't believe that, but who knows?
Who knows, right?
Yes, Your Honor. I'll thank you all for allowing me to go well over the red light.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent.
Mr. Isaac, let me just ask this one question before you jump right into it. If that phone call had been made and the hotel, we're not calling anyone, click, that's it, right? Because they have no duty to call.
Say that one more time. I'm sorry, I didn't hear you.
Please call 911. We think this individual is in the room and they're in danger, they're gonna commit suicide. That's not my problem, click.
No duty at all. Absolutely correct. Except here's the problem. And just two things. I know you know this because I'm here enough to know how you know the cases. It's a summary judgment motion. So when my adversary says, I don't know, that doesn't hurt me. It hurts me at trial.
But no, but you know, I have less of an issue with duty. Causation is a more substantive issue. We don't know what occurred to the gentleman within that hour, assuming for argument's sake that the case law says that you have to show that he's in a worse position than he was before.
No problem.
Assuming that's and there are cases that go both ways. Using that scenario, how have you raised an issue of fact about that?
So let me just, if I can, I'm going to merge both like my adversary did as well. I'm going to tell you what I want you to do, because it's just easier. I want you to look at Applewhite, okay? Because I think Applewhite is absolutely outcome determinative, okay? It's 21 New York 3rd, 420.
I've read Applewhite 100 times.
I know you have.
I want you to talk about the facts of this case.
Sure. So what happened?
No one knows what happened for that hour. He could have been on the ledge for that hour, correct?
Correct.
And you're saying that there is enough there to show causation?
Sure. Because Because here's the problem. When you have a situation where someone is charged with not doing something, then it's always going to be impossible to say what would have happened, because the gravamen of the claim is that they didn't do something. So you're not going to know for sure. If you look at the Court of Appeals decision in Brown, which I said, okay, so I have, fair enough. I have 3 experts, okay, including a psychiatrist, who says that this is a deteriorating situation, that he was in a situation.
The front door clerk should have known that?
No, not this. This has nothing, Your Honor, this has nothing to do with the front door clerk. I'm not suggesting, and my experts, when you read their affidavits, they all say that they don't have to practice medicine. They have to make a telephone call. It's a simple telephone call.
And have
to
they
police an
discharged
hour
their
before.
duty? Have they discharged the duty? Had they made the phone call like they said they would, at whatever time it was, an hour earlier, had they discharged the duty at that point?
Yes, of course, but they didn't.
Why do they have to make the phone call? I don't understand. Why do they have to?
Because if you look at, and I'll give you the pages.
In a lot of those cases that have been cited, the situation is a little bit different. They're in some kind of custodial facility, some jail, some police officer involved, some EMT is involved, things of that nature. This is a hotel where random individual people at a front desk. Why do they have a duty to do anything?
Well, hotels are innkeepers. Innkeepers have a duty of reasonable care. Your decisional law specifically says that a property owner can have a duty to ameliorate areas which could be potential suicide risks.
You're not talking about.
No, I'm
You're not claiming duty. What you're saying that there's an assumption of a duty.
Yes, and they definitely assume the duty, because what happens is the sister specifically says at 359 to 363, okay, you can read it. She says, I didn't call the police because I was relying on the.
Well, that's detrimental reliance by the family.
Correct.
Okay, but again, in terms of showing how did his condition deteriorate over that time, how have you raised an issue of fact?
Well, the expert's testimony is, look, he didn't kill himself right away. The call started coming in at 5:30, and the death is probably around 8 o'clock. You're not 100% sure. So it's not a situation where he didn't call anyone. He was in a state of what they called ambivalence. And this went on. And even the expert, the police expert, Burko, who isn't my expert, talks about how it's important to get the person under control, to make sure that you don't accept what they say at face value. So the fact of the matter is that just because he jumped when the police got there, maybe an hour and a half later, doesn't mean he wasn't salvageable earlier. And if you have an expert saying, look, there is...
How could you possibly know that? That is what I'm saying. None of these people have ever treated that person. They don't know anything about him. How could they possibly come to that conclusion?
Because they're basing it on the facts that are present in the record. Is it okay if I go on? Thank you. Okay, I'm sorry.
You can tell where
Yeah, I got it. So, and I think my point is just a very simple point. If a defendant doesn't do something, just stay with me. If a defendant doesn't do something, the argument that the plaintiff has to prove of a certainty a double negative is not only not proper, but you've said it's not proper in the Stroman decision.
No, but I'm saying this clerk did call the police.
But she
saying
called-
There's a duty not only to do what you said you did, because this clerk did that, but it has to be immediate.
Well, when...
Because somehow that hour is by someone who never treated this defendant and knows nothing about this defendant. That is the causation.
I'm not suggesting that any hotel employee has any duty to practice medicine. What I'm saying is...
but there's no doubt that the woman called...
Late.
Let me go back, because of course it's a horrible, horrible incident. But the woman called, didn't call herself. The hotel clerk is not getting any of these texts, right? The hotel clerk has no idea that these texts are going back and forth between the family and the person, correct?
Well, the hotel has knowledge of it. 306. I just want to read it. I just want to make sure you're okay.
They have the text? The guy is texting?
No, they have a call from Gabrielle. This is what Gabrielle said.
Yes.
She says that he's going to kill himself.
Of course.
So the texts are redundant, right?
Okay, let's just say, and they say, sure, we will call the police. And they did call the police.
Late, over an hour late. I mean, if they called right away, I'm not here.
So that is your whole argument, that they didn't do it quite early enough?
No, not that they didn't do it quite early enough, that they did it miserably late in a situation where they were aware that someone's been excused.
Okay, now that we're on the timeline.
Sure.
And I'm sorry, I apologize, because I know there's something may get lost here with the time differentials between the East Coast and the time zone from which the calls came. But the way I jotted down the timeline was the first call came at approximately 6:40 p.m.
Can I just say one thing?
Absolutely.
Okay. That's probably right, but if you look at 306, line 11, okay, Ms. Anderson actually says, I called it approximately 5:40 p.m. I'm just telling you. I'm not saying it's wrong, but that's...
I think we all agree, basically, there was like an hour, if you will. But I just want to understand something, because I think, as I understand it, your point is, the core of your case is, when we first asked you to call 911, you should have done it.
Correct.
Okay. So let's assume we'll use 6:40, but if it's 5:40, we all agree, though, that the time difference is going to remain the same. So 6:40, the first call comes in, and then it's not until roughly 7:37 the hotel calls 911.
That's correct.
Or runs across the street.
Well, so let me just go into that also, because I want to be technically accurate. I know you're spending a lot of time on this, so I just want to be technically accurate. You're 100% right on the phone call times, but I think you have to add potentially, because I'm the plaintiff moving for summary judgment, so I get the evidence construed in the light most favorable to me. There is abundant testimony that it took about 5 minutes for the attendant to get over to the police officer.
Well, here's where, and this is what I'm interested in, because there has to be, we know that there was some issue from, the police are called and or summoned by foot. Then they come over, to their credit, they came over seemingly right away or within a matter of moments.
Right.
Then they have to get upstairs, Then the engineer, they have to wait for the engineer to come for, I think it was 10 minutes, give or
10
take.
minutes, correct.
Then there was some sort of lock that he was able to access immediately, one lock, but then there was another lock.
The latch he had to get off, correct.
Had to cut through that, which added another roughly 10 minutes to the response time. So what I'm trying to figure out is, if the phone call had been made when you assert it should have been at, using my time for a second, 6:40 p.m. Hotel gets first call. Please call the police. There's something wrong. Okay. What would then the response time, building in, we'll assume these other factors would have occurred. I think that's fair to assume that there would have been a certain amount of time to get upstairs, a certain amount of time to cut the lock. So if they go get the police in the same time frame that they otherwise did, that would mean then that the police officers enter the room at what time? Working from a 6:40 initial phone call from the family to the hotel.
If you're adding that, it's about an hour. That's what I think, and that's what the experts say. It's about an hour, because if you add in, and again, the testimony is not going to be 100% clear because you're dealing with an emergency situation, but I think the testimony that you're referring to, Judge Higgett, there was 10 minutes to get the lock open, and then there was the latch that they have, the safety latch, which they had to call the engineer to come up, and that took anywhere, they say, depends what you look at, 10 to 30 minutes. But I would say it's at least an hour, and that's a long time when someone's in.
But so if they had done it right, so to speak, they get the call at 6:40. Their next reaction is call 911. Someone runs across the street. Now things unfold the way they did when the call was made. What time roughly would that put us at? So we were at 6:40. Call comes in. They respond right away. When does the officer access that room? Is it about 30, 20 to 30 minutes then?
I would say, no, I think there's an hour delay either way, because the way you framed your hypothetical, you're saying, okay, let's forget what happened. Let's take it, what you say, Mr. Isaac, with regard to that. It's still going to be an hour no matter what, no matter how you look at it.
So roughly 6, 7, if they had responded the way you assert they should have, then the first officer enters the room at about 7:40.
He could enter the room at 7:40 to 7:20, maybe 7:15, depending on whether it's...
Viewing the evidence in the light most favorable to you,
sure.
What is the earliest time he reasonably, officer would have entered?
I think he enters the earliest, 7 o'clock, the earliest. Okay. And I'm assuming that there's I know that he was pronounced dead at 8:30, but I'm assuming that the accident...
And you're saying that your expert says that with that built-in half an hour or 40 minutes, that the extra whatever time it is the thing that made the difference?
Yes, because what happened...
Not the 40 minutes that it took them to go across the street, come back. You're saying that that's a legitimate...
100%, and here's why, okay? And again, I just want to make this clear. The expert is talking about generic psychiatric kinds of situations. We have 3 experts, one of whom is a police expert, one of whom is a philosophy expert but has experience in police matters, and we have a psychiatrist. He's basing it on facts that are from the record, all right? This wasn't a person who just jumped out. This was a person who was ambivalent. And the truth of the matter is, and Judge Higgett, if I could just go back for 1 second.
I just want to focus this.
Sure.
Does your expert say that even if when they came, that half an hour it took them to get in the room wouldn't have made any difference?
No, he says it does make a difference. He says in a situation where someone is not taking their life right away and is communicating with his family, either by text or by phone.
So again, how could he tell that the minute it starts making a difference is 31 minutes as opposed to 29 minutes?
It's not a question of whether it's 31 or 29. The issue is, was there a substantial possibility, looking at the case in a light most favorable to the plaintiff, that if they had not delayed an hour and the police had entered, this would have been avoided? That's the issue. So he's not talking about 31 minutes versus 29 minutes or 45
We're
minutes.
all talking about a timeline that has 30 minutes just for them to get into the room.
I know, but the delay in terms of notifying the police is an hour. That's static. That's not going to matter no matter what the police do. So if Judge Higgett asked me about the timeline, we know that there was a call at 6:40, 5:40. She says, I think my brother is suicidal. I think he's going to kill himself. And the call to the police isn't made till 7:37. If you add on 5 to 6 minutes, you're looking at over an hour. That's going to stay static no matter what. And I think the problem for my adversary, and what I'd like you to consider when you're looking at this case, is this. If you take a look at all of the decisions dealing with failure to act, right? There aren't a lot with suicides because there's two. There's a Georgia case and there's a Kansas case. There aren't a lot of cases. There's no case here dealing with this precise issue. But there are tons of cases dealing with loss of chance in medical malpractice cases. You know them
Well,
better than
but
anyone else.
does the med mal standard of diminished plaintiff's chance of a better outcome, is that something that we would apply to this kind of tort?
Well, I'm not saying it's congruent. I'm just saying the theory is exactly the same. And the underlying purpose behind those cases, when you look at Newman and you look at your decision in Feldman, which went up to the Court of Appeals, is, look, it's just not fair to say the plaintiff, you lose on summary judgment on proximate causation because you can't prove something of a certainty when the gravamen of the cause of action is you didn't do that which would have allowed us to determine with exactitude what happened. And I believe, and I'm
Yeah,
sorry,
but that goes to duty and breach. You still have to prove causation.
100%, that's true, but that goes into the causation issue as well. And I'm not trying to quote cases, but I do want, I know you're taking this seriously. I do want you to look at the Brown case because it's a case that I think is completely underappreciated. And if you look at the case, I believe what the Court of Appeals said in that case was that, and let me just read it to you. Quote, this is Brown against State of New York, 31 New York 3rd, 514, 520. And this is on the issue.
31, I don't know
sorry.
if I read that.
It was in the brief.
I've read Appellate a billion times.
I know you have.
But 31 New York
31 New York 3rd, 514 at page 520. This is on the issue of causation. That's why I think this is a very important case. Granted, it's not a suicide case. It's a highway design case immediately subsequent to Turturro. But the argument that was made in Brown was no proximate cause because we don't know what would happen. This is what the court said, not Brian Isaac, it's Court of Appeals. We have never required accident victims to identify a specific remedy and prove it would have been timely implemented and prevented the accident. That's a generic principle of law dealing with proximate causation, and it certainly should apply in a case like this where the reason that we can't determine of a certainty what would have happened is because the gravamen of the negligent act is that someone didn't do something that would have revealed that exactly. That's just fair.
Okay, Mr. Isaacs, I think we've given you enough.
Thank you so much, Your Honor. I appreciate you listening.
Counsel, you asked for 2 minutes. I'll give you 3.
Okay, if I can start with the timeline, because I don't think it was correctly represented during the conversation. The first call came in at 6:39. Importantly, during that call, there was no discussion of calling 911. 6:43, there's another phone call that comes in. Again, no discussion of 911. That's when they then go upstairs. It takes approximately 15 minutes to get him to come to the door. And then at 7:12, that's when there's a call asking to call 911. So if we're talking, the question is now, and this is where the morphing is coming, why it's so difficult in this case, when's the duty assumed? Is it assumed when they saw him? That can't be, because then we're asking desk clerks.
Well, I would say the issue of fact is whenever the clerks agreed to make the phone call, that's when the duty was assumed.
And that starts at 7:12, Your Honor.
And then when was the phone call made?
It was
7:37.
Right, because they called back and asked, well, should I really get the police involved? I think there was a conversation.
There's some dispute about that, but in essence, there's a 25-minute gap.
Still 25 minutes.
It's not an hour. It's 25 minutes. Unless we're going to assume the duty is, and that's why it's in plaintiff's brief this way, of distracting the decedent at the door, that's how you get to an hour.
So between the time when the clerk was actually asked to call the police and the time that the police called is 25 minutes.
It's 25 minutes. And then the police come.
And does the expert say anything about that 25-minute period?
The expert just says in general he's texting the whole time, he's ambivalent.
No, but the clerk
There's
doesn't
nothing
know that.
specified about when.
So it's only when the clerk says, I will call the police, right?
I may be unfairly using Mr. Isaac's words against him, and I apologize if I am. But he said this, the expert's testifying about generic psychiatric principles. And that's what he did. Generically speaking, according to this expert, if they're still talking, the longer you keep them talking, the better.
And did you have an expert saying that that's not accurate?
Well, can I ask you
we
why?
don't.
Let me finish.
I'm sorry.
Did you have an expert?
I
You don't.
can't say we did. But that's.
What about that?
Well, then the point is what that expert is basically saying is until the moment he jumps, he can be saved. And that's complete speculation. Now you're just asking the jury to determine there was some moment in time during this hour, it could have been stopped. And I understand what Mr. Isaac is saying about certitude, and that case law exists, but there's also legion of cases.
What about
say there's-
Ferrer? That both the Supreme Court and Mr. Isaac paid some significant attention to, and is one of those rare cases that actually touches on this, type of issue.
I have to apologize, Your Honors. I've read and distinguished so many cases. That one's not jumping out at me. If you could just give me a brief, what it was. I hate to do that. I'm so sorry.
Young lady is sexually assaulted in a group of
when she was
guards or officers, police officers.
It's not even close, because in that case, the police officers physically restrained a child and kept her in a room by herself, unsupervised, and took control of the person. We never took control of the decedent, to the contrary.
Yeah, but we do say that there was an assumption of a duty, right? So the question is, broadly, was there an assumption of a duty versus what you're saying, 25 minutes versus...
And then just before you answer that, should we be looking at who assumed that duty? The players in that particular case, they were police officers and not a hotel.
So I can answer both of those questions, I think, in one fell swoop. Yes, you should. And importantly, why did they assume a duty? They assume a duty because they took that little girl and put her in an even worse position than she was in. They blocked her from calling her mother. They kept her alone in a room. They did really a horrible thing. They went from not being an agent for good to launching a force or instrument of harm. And that's the fundamental question. Were we not an agent for good, or did we launch a fundamental instrument of harm? And I would submit in this case, we didn't launch an instrument of harm, and the only way you get to us launching an instrument of harm is if you assume this could have been stopped.
May I ask you, did the clerk say why she didn't immediately call the police?
So that clerk at issue wasn't deposed. She left the country by the time the litigation came. So all we have are the two versions of hospital management saying they can't believe she said that, and the family just saying she said that something to the effect of, once we sort of cross that bridge, we can't undo it, something to that effect. But basically, it's really bad if we call the cops. You sure you want us to do this? It's going to open a can of worms for everybody. Is that really what you want? That's what the plaintiff said. We deny that. I don't have the exact clerk to give you, though.
Okay, okay, thank you.
Thank you, folks.
Thank you.
Thank you all, Your Honors, and thank you for allowing us to go over time.